Hi, everybody. It's me, AV. We're back. This is the second stream for me today. It's been a long day, and I know you guys are really eager to get to today's interview. We have a very special guest with us. I'm not even going to waste time. I know you guys may have some questions. I'll ask that you hold that to the end. I really want to be respectful of our time today. And we're going to have a really good discussion. You guys know here on my side of the house, we really like to edutain you guys, but also at the same time, educate you guys on how the law works, understanding what some of the proceedings look like after the fact, really just have like a chill discussion and help you clarify certain things. Now, I love you guys because on Friday, you were very hard on me in the comments and you're like, hey, sometimes there are things that are done for legal strategy. And to help bring that together, I have invited Doug Weinstein, the attorney for Gotti, Diamante, Kendrick, here today. He had a fantastic day in court. It was such a huge win. And I want him to help kind of explain what took place today and how big this was for his client. And also for you guys to learn a little bit more about his client and what this case has been like from someone that's been in the courtroom doing this every single day and advocating for someone that's been involved in a very complex legal case. So without further delay, I'm going to go ahead and bring up today's guest. We have Doug Weinstein here. Doug, how are you? Welcome.
I'm great. Hey, AV, how are you?
I am good. Thanks so much for coming on the platform today. I know you've had some time in court and you worked with Megan too, so that was good. I so appreciate your time and making the time to be here.
Yeah, and just for everyone commenting on you being late today, I just want to say, to the extent that AV is late today, it's because I kept her held up. And also, it's really in keeping with the YSL case that we start things late. So
yeah, I'm sure. We've seen that. Like we've had many delayed mornings and we saw that I think on June 7th, right? A little bit of a delay there.
Always late.
Yeah. Amazing. So Doug, I would love to just start by allowing you to introduce yourself. How have you been involved in the case for newer folks that are just now keeping up with it? Tell us a little bit more about you, your practice area, and things of the like.
Sure. So again, my name is Doug Weinstein. Hello, everybody out there. I am one of Gotti attorneys, one of Diamante Kendrick's attorneys. I work with Jay Apt and also with Katie Hingerty. So the three of us all represent Diamante. So when you're watching the YSL case or you're reading about it, it could be one of any of us in there at any given point in time. I am the attorney that tends to be in there most of the time, but sometimes we'll all be there. And I've been working on this YSL case since almost the beginning, and in trial almost every day for the last 18 months.
Wow. And tell us a little bit more about Diamante. What are the specific charges that he is looking at with his involvement in this case?
Right. So he faces a number of charges here. Sorry about that beat.
No,
he faces a number of charges here. He's been charged with racketeering, with gang activity. He's being charged with a host of charges related to when there was the arrest of Jeffrey Williams, Young Thug, at his house in Buckhead. Diamante was there, so there were some guns that were there. There were some drugs that were there, so there are charges related to that. And then there's the charge that we're really in the middle of at trial right now, which is there's a murder charge that he faces, alleging that he was involved in the murder of Donovan Thomas.
Got it. Now, recently, we know the last 3 or 4 weeks have been pretty heightened with what has been happening, especially with the ex parte communications or the ex parte meeting that happened. You've played a significant role in that in the past few weeks because we saw the filings go up to the Supreme Court and things of the like. I really just want to start with a background as far as today, right? We've been hearing that a lot of those filings did come from legal strategy, right? And that's one thing I really want to clear up with my audience too, because, I had made a blunder last week and I was just like, oh, well, we filed this in a court that it should have been filed in. But at the same time, if Glanville is making decisions, like how do you go from step 1 to to step 2 to step 3, right? You have to have some strategy with those things. Can you share some insight on your strategy that led to the case being reviewed by the Supreme Court and then ultimately, being assigned to the Superior Court?
Sure. Let's talk about this. So, on the 10th of June is when that secret ex parte meeting took place. And I learned about that at the same time as Brian Steele, from the same source as Brian. And of course, Brian brought it up in court on the 10th. Based on that, on the 12th, that Wednesday, I went to the judge at the end of the day, and I filed a motion and I gave it to the judge. And I asked the judge to recuse himself from the case. And there's certain steps when that's done. There's a process in the rules here in Georgia of exactly what has to happen then. So, for example, when I asked the judge to recuse himself, he's required to stop doing everything he's doing. And he has to see, well, is the motion filed in a timely fashion, which it was because it was within 5 days of what I was complaining about, which was the secret meeting, the ex parte meeting. In the affidavit, the document that I filed where I provide the allegations of what happened in that meeting and why he should be recused, does that, were the I's dotted, were the T's crossed on that affidavit? And if you read the affidavit and you assume everything I wrote is correct, should he recuse himself? And if the judge goes through that process and says, yes, I mean, I'm not going to argue with the facts because I'm not allowed to, but if everything you say is true, then perhaps I should recuse myself. And therefore, I, as the judge, need to have another judge determine whether I should be recused. Recused just meaning being removed from the case and another judge taking over. So I did that, and I don't believe the judge followed those steps. And some of you may have heard me argue that the judge didn't follow those steps. So he denied my motion. I asked him if I could appeal that to the Court of Appeals immediately, and he denied that. I suggested that there was a bit of a cloud hovering over the case because of the situation, and he took offense to that and warned me to tread lightly.
We were watching that when that conversation happened, and even just the certificate of immediate review. A lot of us were rooting you on from home because we noticed that he didn't allow you to really get a lot of words out in that moment. So it was nice to be able to read through your affidavit, and particularly, we'll come back to this because I want you to finish your thought. I actually spent some time on the affidavit included from Attorney Tate, and we went through his background, his history, and his opinion. I thought that was brilliant. So I want to compliment you on that, and we'll come back to that. But we didn't see the certificate of the immediate review. I don't think he even, he said it first, like, no, I'm not going to grant it. And we didn't really get a lot of discussion.
He refused to grant that and took offense that I asked for one, or really took offense that I said that there was a cloud hanging over the case. So, and I don't want to take too, but when it was denied, at that point, I had a choice. Okay, we had a choice. We could go through the normal process of petitioning in Fulton County to have another judge force Judge Glanville to follow the proper procedure on recusal, and have another judge make that decision. Should the judge be recused? So I filed a petition, and anyway, I could file that petition in Fulton County, but I also could file that petition with the Georgia Supreme Court. And given that the judge, Glanville, had 2 previous petitions seeking something similar to what I was asking for that had sat on his desk for almost a year, I thought, if I file this in Fulton County, it's going to go nowhere. We're not going to make any progress. And even though the Georgia Supreme Court says we can hear these petitions, but really our rule is you go to Fulton County first. So I wasn't exactly anticipating winning in the Supreme Court, but what I was hoping for, I mean, I would love to have won, but absent winning, the next best thing is to get some kind of ruling from the Supreme Court that would tie the judge's hands, where if I did go and file in Fulton later, it couldn't just sit there. So last Thursday, we did get that ruling from the Georgia Supreme Court that said, no, we can't hear the case, but here are the steps you need to do. And by the way, this can't sit at Judge Glanville's desk. This is going to need to go, and another judge is going to need to hear it. And if that judge doesn't grant it, well, you can always appeal that. So that's kind of where we are. So last Friday, I filed in Fulton, and then I spoke to the judge today. But anyway, the judge clearly had gotten some guidance, some counseling. It changed his mind.
Something happened over the weekend, for sure.
Right. So he gave us everything I asked for in the petition today. He put the case on hold. He's referring it out to another judge. He's giving us the full transcript. So everything I asked for in those petitions, we're getting anyway. So that's great. We're really happy with where we are.
That's great. And you know, I'm sure Diamante is really excited about having a win today in court, and happy that at least there are some things that are progressing. And it looks like there's, that's good. That's good. Yeah. How has his demeanor been throughout this process?
You know, I've gotten to know him so well, and it's almost like family when you sit next to someone every day for 18 months, all day in court. So I think we've grown close. He's a really good guy. He's very intelligent. He follows everything going on in court. He asks excellent questions about things. He's able to follow my guidance. And I think, considering that he has been really incarcerated now in Fulton County Jail, which is a horrible place.
Oh, we've heard about the bed bugs and just the jail rumbling.
So it's terrible. He's been incarcerated for 26 months, but he still has great spirits. Some days are harder than others, but he's doing really well. And this was a big moment for us because we fully believe if we get a fair trial in this case, we're going to get not guilty verdicts. And now we're at the point where we're questioning if we're getting a fair trial. So maybe if we get another judge in here, we'll get the fair trial that everyone is constitutionally required to have.
Yeah, that's fantastic. And just diving into the significant court win, congratulations, firstly. It's huge. I think it will definitely lead to some victory for you guys. Can you elaborate a little bit more about how important this win was today and how specifically it's going to interact for young Yak Gotti moving forward? I think you kind of provided that a little bit because it seems like there's a goal of getting the not guilty verdict. But tell us a little bit more about that.
Yeah, I mean, of course, we want to have victory. We want to have the not guilty verdict because that's what really the law demands. Don't believe, and anyone that's watched the trial, I think, will be the same place we are. We don't believe the prosecution's been able to show, at least yet, and I don't think they ever will be, that there's guilt beyond a reasonable doubt, because in fact, he's not guilty of these things that they accuse him of. So I think that's why the state is having such a challenge. If we can, and it's been evident, I think, for a while that perhaps we have some bias from the judge in his rulings. I doubt that they're conscious bias. I think Judge Glanville's a very good man. I don't believe he's consciously out to get us or ruling against us, but I can't help but look at a number of rulings and see the way they're going. I mean, we had a big victory in front of Judge Glanville in April when Judge Glanville threw out Diamante Kendrick's interview that he gave with the police back in 2015. So that we do have our victories, but all in all, it's not, we just don't seem to be getting the fair opinions that we'd like to see, the fair rulings that we'd like to see from the judge. So if we can get a new judge in here who I think is going to be unbiased, we're going to get better rulings, and we're going to have a higher likelihood of the proper outcome in this case that all these defendants deserve.
Wonderful, wonderful. Yeah. And then going back to Tate for a second, because, you know, when I really took the time to go through the document, and I thought his background was fascinating, you know, to, you know, be very, very respected in the legal community in Georgia, all of the accolades, all the boards that he serves on, to get an opinion like that. What was the strategy behind that? Because it seems like, you know, having his opinion from an outside standpoint, just look at Judge Glanville's conduct. What was the significance of including that in this review for you guys?
I think one thing that all your viewers or listeners need to appreciate is the outpouring of support that we have had throughout the trial, but particularly once the criminal defense bar learned of this ex parte meeting, and then topping that off with holding Brian Steele, an attorney with a immaculate reputation for honesty, for integrity, for professionalism, finding him in contempt. So many criminal defense lawyers reached out to us offering to help in Georgia and actually throughout the country. I've got people that have pitched into this case. I need to thank them all, because
That's
the
fantastic.
petitions that I filed, the motions that I filed would not be this good absent all the help they've given. And Lester Tate is one person that reached out to us and said, this is just wrong, what's going on. The judge isn't following the rules. This ex parte hearing this ex parte meeting should have never taken place. When I filed my recusal motion, as I said to Judge Glanville in court, Judge Glanville didn't follow the procedures. So having someone of that weight weigh in with their affidavit, I think was tremendous and more valuable than anything I wrote in my motion.
Yeah, it was. It really was. And with this audience, I had an opportunity to go through the first few pages with them on the lead attorney side. But as I looked through the affidavit, I was just like, wow, this is interesting. I love that this was included. But then, I really took the time to go into Lester Tate's background, his experience, his training, and really get the audience to get to know, like, hey, this is a heavyweight here weighing in on this. And there's a big difference between, because I think Judge Glanville said this, the orders, right, his rulings, but also his conduct.
Right.
So we underlined that 100% because I wanted the audience to walk away and understand that.
I'm so glad you educated your audience on that, because Judge Glanville misrepresented what I had in my motion in court.
Yes,
I never, ever complained about his rulings or his orders. I was complaining about conduct, and conduct that I maintain based on what I learned, assuming that what I learned was correct, was in violation of the Judicial Code of Conduct. And it's conduct that merits recusal. So I was taken aback, honestly. I don't know if you could see my reaction in court, but I was surprised that he would mischaracterize what was in my motion in that way, especially because anyone watching would not know what was in the motion.
Exactly.
There's no complaint in my motion or in my affidavit about anything other than conduct. And then to have Lester Tate weigh in and also make that distinction was really important. If I wanted to file a motion to recuse every time that I was unhappy with a ruling from Judge Glanville, well, we could have done that hundreds of times. I don't have
especially over these few months,
Yeah, I would never ask him to recuse based on rulings. I would only ask him to recuse based on conduct.
Yeah, I'm happy you mentioned that, because, that was one thing that we kind of learned together, because in the moment when we're watching a live feed, a lot of folks are not really knowing what's going on at home. So what I like to do is stop, explain what's happening, and then just kind of come back to it later and go deeper into the topic. So, I'll tell you that these guys loved the time that we spent just on that part, just with Lester's experience in the underlining of the conduct versus the ruling. So we are Team Weinstein over here. If you guys can type in Weinstein in the chat, that would be fantastic, because Doug is definitely doing what he's doing for his client, but also just, this is a great example for up and coming attorneys like me, but also, folks that are interested in the law. So with that being said, I want to shift now to some of the challenges you guys face. I think some of these came up as we were chatting. What were some of the major challenges throughout the beginning? And it's been long, between jury selection till today, little Woody. I mean, we've all seen it, right? Yeah. All of those things. What were some of the biggest challenges throughout the process you guys have seen, and how did you overcome them?
Yeah, well, I mean, there's been a number of issues. I think obviously the 10-month jury selection was long and tedious and exhausting, and staying focused throughout what was a relatively boring but important process was hard for everybody involved. And also we were in the dark because none of the defense attorneys, or even the state, I believe, knew how long that process was going to take place, because the judge would never say how many jurors he was going to bring in. As far as substantive challenges, in Georgia, the law says that the state is supposed to give you all the evidence that they have before trial begins. Our trial began in January of 2023. So we should have had all of that evidence in December of 2022. And yet, if anyone who was watching during that long searching for jurors, the state was constantly giving us new discovery throughout this process. So we're trying to do our job in court. We're trying to do everything else at the same time that the state is dumping terabytes of discovery to us 6 and 8 months after it should have been provided to us. So having to comb through all of that has been a real challenge for the whole team. Yeah, so discovery, really getting through I think we have 8 terabytes of discovery.
That's a lot, guys. Like we can quantify what 8 terabytes, just 1 terabyte is a ton, but 8 terabytes is so long. And even for us last week, I did, stream some of the proceedings with them, but the phone calls, we're getting through those, or at least we're going through them now. But little Woody's interrogation footage, I go out, my heart goes out to you guys to have to transcribe all of that and then go back and forth with each side to make sure we're okay with what's coming in and rule on each one.
I'll tell you, there's so much work to be done. Max Shart has carried a lot of the weight of going through the transcripts and identifying that stuff, along with Brian Steele's team. So kudos to them for all that they have been doing. There's no way any of us, I think, could get through this trial without the other defense attorneys and all of us all working together. And we are, having been involved for 25 years or more in a lot of cases with multiple parties, multiple defendants, having attorneys that actually can work together, set egos aside, cooperate. It's a miracle to find a group that can do that. And I'm just blessed. We are all blessed to be working with each other and have a team that gets along so well together.
That's awesome. Yeah. And, we've also talked a lot over here about how uncommon it is with RICO cases. Like we see them, but not as often. I know that is it's a challenge because you have so many defendants. There are other cases in the state of Georgia that have RICO attached to them. And we know that it can be a big resource. It can deplete resources from the government in a sense, right? Like these are taxpayer dollars, things of the like, and it's got a lot of eyeballs on the case itself. And, I try to mention to them that usually it's one table against another table, but you guys are like a sea on one side. And we often mention how, even if it is an opportunity to approach the judge and, sometimes we would have to look at things if the state is bringing something up for you guys to all talk to the judge. And there would be so many of you coming from the defense side. It's like a little army, but it's we mention how that is uncommon in the everyday courtroom.
Right. We try to, we have 6 defendants. We try not to send 6 attorneys up to the judge's bench when he needs us, just a couple of us. When that happens, though, I hope your viewers understand, your audience understands that we're all listening in when that's happening, including our client. So anything happening at the bench, we're all hearing. So we all have the opportunity to weigh in on everything. But unlike the state, I think we try to be efficient and move things along.
Yes. Yeah. Oh my goodness. Like even these guys were sitting here with me for hours watching it. And I try to balance out my study schedule for the bar. And I'm like, okay, we can only do a few hours today because I really need that time to focus on other things. But it's really interesting because sometimes they are watching and they're just like, why is it taking so long? Why is this happening? Why weren't some of these things done during the discovery process or pre-trial? But it seems like some things are reactionary. Would you agree with that?
I'll give you an example. This issue of having to go through all the transcripts for Mr. Copeland and identify what should come in, what should not come in. Normally, that would be something that you would do before you have the jury seated. Yeah. But I guess the prosecution would say that they didn't expect. I mean, I don't know what they would say, but I guess they would say that they didn't expect Mr. Copeland to testify inconsistent with his. And by the way, I don't believe he testified inconsistent, but they maintain he testified inconsistent with his prior interviews. I don't believe he did, but they say he did. So they're going to say, well, we didn't anticipate needing to bring in these interviews. I don't think they should come in right now.
Yeah, because it's essentially been, because it's essentially been the last 2 or 3 weeks we've been focused on this. Like, that's where we've been.
Yeah, because we've got, I don't know, a dozen hours of these interviews to go through, and it takes a long time.
Yeah, and we haven't touched the jail phone calls yet. It seems like that's coming.
Those aren't going to take as long. I think we can get through that pretty quickly.
Okay, got it. Because I think one of his interviews and the audio, does it sound different in the courtroom? Because from home, the audio of those interviews, it's just like, what is happening? Like the audio is not the best. So we all suffer listening from home. I'm like, all right, guys, there's a headphones warning. Take them out for a second. So we often go through that. Shifting along to the implications of the trial, right? How do you see the decision that was made today impacting the dynamics of the trial? And do you anticipate any like broader implications in the next few weeks for any other defendants?
Well, I think the implications, I mean, and for what's going on right now with the recusal, all of that affects all the defendants the same. I think we're all impacted no matter what happens. So if the judge is recused, we'll all get a new judge. And then a decision will have to be made of what happens with the trial when we get that new judge. Does the new judge slide in and we try to rewind everything back to June the 12th? Because that's what the law requires. How do you rewind what the jury has heard? Can you rewind what the jury has heard? I would argue you probably can't do that. So do you have a mistrial? Well, we'll see how things go.
Wonderful. And then just to close, because I know we're kind of short on time here, but I want to be respectful of your time as well. Yeah, absolutely. What are the next steps specifically for your client, for Yak Gotti, for his legal journey, Diamante? How do you plan on building on this momentum and securing a favorable outcome for your client?
Okay, so what's going to happen next is some judge eventually is going to hear this recusal motion. I hope that they're going to be hearing it next week, ideally. I don't believe any judge in Fulton County can hear it. So I think it's going to eventually be moved to a judge outside of Fulton County, which could potentially delay things a little bit. But I'd still hope it would be heard next week. The judge does not have to, under the rules, does not have to have a hearing. The judge could just rule on the paperwork. But given the profile of this and the charges, I would imagine that any judge would want a hearing. So we'll have that hearing. We'll await the ruling of that judge. I wouldn't have filed a motion for recusal unless I thought one was merited. So we should, hopefully the judge will be recused, and then a new judge will be assigned to the case, and we'll see where things go.
Wonderful.
And I don't want to betray too much of future strategy because, again, there's a lot of this thing can fork, and we'll just have to see where things go. But I will tell people, we have a plan for every option that could happen. So we're ready to go no matter what happens.
That's good to hear. And, we had Kayla on today to get her reaction after what had taken place today with the judge, because she had an active motion to quash. She was supposed to appear on July 3rd. So we had an opportunity to get her live reaction, and also hearing that the full transcript is going to be made available. That was news to a lot of folks. And then before I let you, exactly. So before I let you go, just because those are recent developments that came out today, what was your reaction when you heard that the full transcript would be available? Because Judge Glanville just really held on to it. And we even asked Kayla, when she wanted to be recused, he kept going back to the 10-day rule and speaking to Mr. Copeland about that while he was on the stand. So it seemed like everyone wanted Kayla to be excused except for Judge Glanville for some reason. So I'm just wondering, with that whole ordeal and the secret meeting that folks are calling it, but this ex parte meeting, and to finally be able to get a full transcript, not a redacted transcript. And, it just seemed like we were throwing the football around or kicking it around, kicking the can down the road, so to speak. What was your reaction when you heard that it would be full and unredacted?
Well, first of all, my reaction is that's exactly what we should get, because while the judge was saying was alluding to privileged information in the transcript, I was racking my brain and wondering what I missed in law school that could possibly be privileged within that meeting. And I think some of the things that I said in my motion, so there really couldn't be anything privileged in there. And I guess the judge came around to that today. So I'm thrilled to get it for a number of reasons. One, we should get it. Second, let's have some sunshine. If nothing wrong happened in there, if the judge is confident that there's nothing wrong, there shouldn't be any issue with releasing that transcript. If what I said in my affidavit is inaccurate, because it's just on information and belief, it's just based on what I was told. Let's see it. If I'm wrong, I'll say I'm wrong. But all I can go off of is what I've been told by my source. So I'm hoping the transcript is an accurate reflection of what happened in there. And if it is, we'll find out if I'm right, if I'm wrong. If I'm right, I think the judge should be recused. And let's let the transcript show what it shows.
Awesome. And Mr. Weinstein, before you go, I just have one quick question. This question comes from a viewer, and she's super important to me. So I just want to bring it up, and we can answer it together. Shout out to Anna P. She sends a $20 super. And Anna asks a question for when it's appropriate. What sort of appeals process, complaint, or action can attorneys take when the judge doesn't allow the attorney to get something on the record? I noticed Judge Glanville has done this a lot.
In most cases, the best that we can do is to make sure that there's a record created in the transcript of what we tried to get on the record as best we can, to do what we call proffering the information, which is putting it forth as an officer of the court of what we think this will be. That will get that into the record. And then, unfortunately, most of the time, we just have to wait for the appeals process to say that the judge made an error in not allowing us to get that onto the record. And if it goes back for another trial, that judge should let it in at that point. But most of the time, that's what we're limited to. Sometimes we can ask for a certificate of immediate review, but that's rarely granted, and there's few occasions where we can ask for that. So a lot of times we're just stuck with it and we make a record. And you'll hear Brian Steele say that a lot. I'll just need to make a record, Your Honor. Max will say, if I can just finish so I can make a record, Your Honor. And the prosecution will do the same thing.
Got it. Well, Mr. Weinstein, I appreciate your time today. Thank you so much for joining us. We love you over here. We're always rooting you on and cheering you on while you guys are in the courtroom. And we're like team defense at this point. So we love to see the right thing happen, and definitely advocates for
and Diamante is a great guy. He's innocent of these charges. I want to get him back out there so he can start making some more music and doing some more concerts and doing some more shows and doing what he loves and is great at, I think. So thank you all.
Thank you so much. Thanks again, and we'll see you soon.
Thank you.
All right, guys. Bye now. All right, guys. That was cool. That was one of the first times that I was able to get a active participant in this case on my side of the house, right? Oh, shit. Oop. Where did we go? There I am. Sorry, guys. I lost my window for a minute and dropped the S-bomb. That was unprofessional. Anywho, I thought that the stream died for a second. I'm like, what happened? But anywho, what I want to do, we heard from Doug. I want to kind of walk you guys through what happened today in court. And after the fact, I do have some breaking news for you. Not breaking, but there was a new filing that we did not anticipate today. And that came from Brian Steele. We have a document that was filed at 5:02 p.m. You could see the timestamp on the top right-hand corner, and that's in the Superior Court of Fulton County, state of Georgia against Jeffrey Williams. So we are going to go through that together. I'm going to give you a synopsis of what happened today. But before we do anything, I just want to acknowledge a few of you guys that have left super chats. You've been super supportive in the chat section. It was great to have attorney Weinstein on here on a day like today where his client had a win. You know, Doug's team, he did a really good job, and we learned a little bit more about him and his client Diamante. You know, I really try to respond to you guys' feedback. You know, that last stream that I did, I think it was on Friday, it didn't sit well with me, I'll be honest, because I made a blunder. I mentioned that, you know, the filing was a mistake, right? And you guys went to town in that comment section. When I tell you, like, I was with my family over the weekend celebrating a birthday, I got comments like every 2 minutes, like, disagree, do not agree. I used the word mistake, and like mistake was highlighted with a million highlighters. So I really thought about it, and I was thinking about it this morning. I said, you know what? I think it'd be really nice to get Doug on here to look at that. So I just wanted to start this because this is my time to really connect with you guys before we get into that legal document. I really want you guys to understand like how thoughtful I take content creation and how much it means to me for you guys to learn about the law, not only from a light, fun, lighthearted way, but also in a way that's digestible. But in addition to that, if there's feedback, like, I'm not afraid of it. And I'm going to bring you the best, the very best that I can in order for y'all to like really learn. Like, that's how much I'm committed to this channel and to you guys, right? So I hope you really enjoyed, you know, seeing that, having a lawyer on here that is involved with the case and is there every day, and is also responsible for us to really look at the conduct of Judge Glanville. So I hope you guys appreciated that. You know, I'm really happy that we were able to have attorney Weinstein on here. Let me go to a few supers, and then we will bring you up to speed on what took place today and give you a sneak peek of the document that Brian Steele filed. I'll be honest, it's 104 pages. I'm going to just go through the first 8, and then Lead and I will pick it up tomorrow because this is stream number 2 for me today, and this is really important to get done. So shout out to Miss Crotichette with a $10 super sticker. I appreciate you. Thank you so much for the love, the support. She is one of my longest running subscribers. I appreciate her so much and all the support that she's provided. So thank you so much, Miss Crotichette. Shout out to Forever, For Always, For Life. She sends a $2 super sticker. Or a super chat. She says, how do you get a true unedited transcript? Well, good question. For Always, Forever, For Life, lots of fours. The way you get it is there's a court reporter, and I don't know if you guys have noticed, there's a woman that typically sits in front of Judge Glanville. You guys remember Woody talked to her and asked her what color sneakers she was wearing, and she was wearing Chucks, right? That's the person that's a court reporter in this particular case. Now, what she does, her job is she has a small device, looks like a little typewriter. She is sitting there all day and she is typing out everything that's happening in court. And sometimes people like, see, these guys are they're like so good at being typists that they can type without looking down. Have you ever tried that? Like start like typing and like looking around. It's a very unique skill. Like try it. Like if you can do it, that's great. Like without ever looking down. But you know, I've just also noticed that you know, you'll see the court reporters do that from time to time. Now, the other thing to consider is how you get an unedited transcript. Well, we would have to get the raw. We would start there. Start with the raw transcript that she had from her notes. And of course, you got to edit for like grammar, for all of those things, right? It can be, you know, it's not going to be the most cleanest version, but they would typically start there and edit for the basics. In addition to that, it would be circulated, but there's some things that, you know, are like, shouldn't be redacted. So you heard Doug mention this a second ago. That transcript should have been made available without redactions, right? But it turns out that Judge Glanville wanted to provide it with redactions because there was confidential information in there. There was privileged information in there. What does that mean? When something is confidential or privileged, that means that if it's revealed, one of the attorneys would be breaking attorney-client privilege. That's like a fundamental thing when it comes to any attorney-client relationship. And you guys, I tell you all the time, there are certain tests that attorneys need to take to be barred. You have the bar exam, but another one's called the MPRE. And that's where we follow the model rules of professional ethics. And that is federally, that is across the country, we follow these rules, but every state has those rules of ethics and canons as well, right? So you'll see that. Now, that's why this one was redacted or was going to be redacted. And then miraculously this morning, we heard that they were going to be made available in their original, not original, but at least in an unredacted state. So I hope that answers the question for our always, forever, for life. Again, shout out to Anna P. We got your question answered. I'm happy that Doug was able to answer that one for you. Shout out to Miss Crotty Sheddy. She is back. She is back with the $5. She says, AV, you are the best. I see green and red. Are you back? AKA Miss Crotty Sheddy? Let me know. Let me know. Shout out to Christina who says, now can we please talk about Tay? Ooh, Christina, I was going to do my shorter videos. I have an editor assigned to do this today, but I really wanted to bring Doug on first. Let's talk about Tay for a little bit, but just know I am working on a more comprehensive video for you guys. It is short. It's going to be about 10 minutes long, but we did a little bit of digging, me and my team, over the weekend to understand who Tay is and how this works. Now, Tay is a party that wasn't necessarily a party to the case, but someone that Little Woody alleges was responsible for a shooting. Now, Tay was murdered over the weekend. I was in Atlanta this weekend. I just got back last night, guys. And I was honestly going to go to the courthouse today to meet some of the attorneys in person and, see what was going on, jot down some notes, and then come home and stream for you guys. And then, decided to go down a different direction. But Tay was murdered over the weekend. So I think it was early Sunday morning. He was murdered. A lot of people thought, because there's another person that I believe is involved with YSL, and his name is YSL Woody. So a lot of people thought YSL Woody was responsible, or YSL Tay, or the names got mixed up and it was the wrong victim. It's a different Tay. This is a Tay that is very close to Little Woody. They were close at a time. And I was monitoring Little Woody's Instagram posts because he posted it. Like it was up. He posted pictures of this gentleman named Tay who passed away, right? He seemed to be very young. Now his home was shot at, and Tay was inside of the home, but he was home alone. Okay. It was a big shocker because, I have been working on another video. It's more of a crime deep dive, just on the specifics to teach you guys, okay, when you're a sworn in witness, is it smart or is it the best idea to go on social media and show where you are, things of the like, so, Little Woody had posted something a few days ago where, he says like he'll be out and about and people are like, hey, you're Little Woody. And he's like, for your safety and mine, don't run up on me when I'm out in public, right? You should probably be careful with that, right? Because, I'll tell you, Atlanta's small. Like I was there and I told you guys, like, I think it was like Saturdays, I was about to get my hair done and I was ordering an Uber and somebody came up to me and they're like, are you AV? I'm like, oh my God, I got recognized, but yes, I am, right? So these are just some things that happen while you're out and about. So I can understand why Little Woody would say that. Now, when you're out and about and you're posting things to a story, you're showing people where you are, you're showing people your location, you're talking about this case. People have seen that Little Woody, we watched the interrogation footage. So people that are, I don't know, possibly involved in street gangs, what is being live streamed is available to everyone. And you never know who's watching. So for safety purposes, I'm a little startled at the fact that he would share his location and things, and to each your own. He doesn't have to do it, but he's doing it. And maybe that's because he doesn't have fear of what could happen. But like, even with the whole thing with Tay's name is being bought up in these legal proceedings, and they've been bought up several times over the past few weeks. So it is interesting. Many of you guys have had theories that it could be connected to this, or is it in retaliation? Did Woody have something to do with it? I really appreciate the truth over here. So I'm going to go with law enforcement puts out there. Like, we're going to look at those things. We're going to look at actual documents, actual filings, actual facts, because the rumor mill has already started over this thing. And the rumor mill over the weekend was wrong. Like, at some point, people thought little Woody was taken out over the weekend, which would have been on every headline everywhere. But that wasn't the case. So I really want to be cautious and careful with information that we find online. And I really want to report it in a thoughtful way. So, Christine, I hope that provides some color on it. I was wondering if that was going to come up in today's proceedings. I don't believe it did. And if it did, it was probably light. But we are working on like more of a digestible 10-minute video that talks about that situation more. So I hope that helps. Shout out to Vintage CB. I sent you an email. Thank you so much for becoming a member. I either sent you an email or a DM. We have some time coming up, so I just want to make sure it gets scheduled. Vintage CB gifted 5 AB to the 7th power memberships. Thank you so much, Vintage CB. If you guys can do me a favor, and I like that art there. If y'all could do me a favor and type in VCB in the chat, that would be fantastic. If you were one of the people that got a membership from him, please say thank you. Very, very kind. Shout out to Question Everything, who did the same thing, gifted a membership to one lucky person in the chat. So if you received it, please say thank you. And Question Everything, thank you for supporting your fellow folks in the chat. Janelle gifted 5 AV to the 7th power memberships. Thank you so much, Janelle. That was very sweet of you, sis. I appreciate that. She is giving 5 more of you guys access to our community, access to memberships. And if you guys received a membership, please say thank you. Janelle's a sweetheart. She's amazing for doing that, and I so appreciate her. Shout out to Peg Wardo. Peg Wardo has been a member for a month and says, is there any chance they can be released from jail? No, I think attorneys like Doug and others are working hard for their clients every day. If there was a way to have them released, and there are certain parameters around it. Do you want your client to take a plea deal, right? Most of them said no. I showed you guys the proceedings on Friday where we saw the state present multiple defendants with plea deals, and they all said no, right? So you have situations like that, right? Shout out to Madi with the $25 who says, bad faith horse trading by Glanville shows his ego and pride cannot handle exposure. That may very well be the case, Madi. Thank you so much for the 25 super. Shout out to Audrey with the $4.99. She says, you're doing it today. Yeah, I'll be honest, guys. I'm getting a little tired. So I'm going to go through these memberships real quick, and then we're going to go straight to Brian's document. And then we will come back tomorrow with more fun-filled things on the agenda for the YSL case, because there's a lot more to cover. Brian's document is probably going to hit headlines throughout the next 24 hours. And remember, we're still waiting on the transcript. I have a source that's very, very close to the case that is just letting me know when the transcript is expected to be filed. From what I've seen, it hasn't been filed yet. So we're going to go with what we see here. Okay. All right. I saw 114 pages and I'm like, wait, is this the full thing? And I just remembered I just have the 8. So we'll go from there. All right. Thank you, Audrey. And yes, I'm doing it, guys. And fresh off a plane yesterday. So I'm doing a lot to make sure that you guys get the content that you need. Shout out to Terica, who's gifted 5 memberships as well. Terica is amazing. I did see your DM. I haven't answered it yet, but Terica actually made a lo-fi beats playlist for me. Haven't listened to it yet, but I highly recommend her if you guys are looking for music to listen to on downtime. And shout out to the Mushroom Podcast, your main man Mush. Lots of words there. He's also gifted AV to the 7 Power membership. So if you got one from the one Lo-Fi, so if you got one from Terica, or if you got one from Mush, please thank them because they just gave y'all 10 right there. Shout out to Devin, who says, how do you become a member? There's a join button if you're watching from a computer. And if you are trying to join from your phone, I believe that join button is there as well. Okay, let's go to Brian's document because you guys were like ready for it. You were ready for it. So here's what we have. This is a notice of attorney proffer after being prohibited from cross-examination and presenting a full critical defense at trial. Now, that is a long title. What does this mean? So this is Brian Steele basically filing a document showing that he has been prohibited from cross-examining a witness. I'm guessing that that witness could be Little Woody, but we're going to see what's happening. He's filing this on behalf of young thug Jeffrey Williams. So we're going to read what he has to say here. And when he can't cross-examine this witness, what happens? It is preventing him from presenting a full and critical defense at trial. Notice that we use the word critical here. That is important. Critical is like, you know, we talked earlier today about the stages of trial. When you're at a critical stage of it, it's a really important part of the trial, right? And this is one of the most important witnesses. I think I read somewhere that Little Woody, it's kind of poetic, like Little Woody is one of the reasons why we have this trial. And he's also the reason, on the other hand, that the trial is falling apart. So it's really interesting in retrospect to see all of that, right? All right, so let's see what Brian has. He says, come now, Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this notice of attorney proffer after being prohibited from cross-examination and presenting a full critical defense at trial in the above referenced case. In support of this notice of attorney proffer, Mr. Williams' undersigned counsel shows as follows. All right, now we're going to talk about what an attorney proffer is, but we're also going to start with some background on what he's talking about, okay? So on Tuesday, May 14th, 2024, during the direct examination of Agent Ricey, lawyer Hilton, representing the state of Georgia on behalf of the Fulton County District Attorney's Office, played over confrontation clause and hearsay objection in October 2022, 2015, 9:33 recorded jail phone call of Mr. Jimmy Winfrey, a person known as Rashad. During this call, Rashad explained that he heard from another unknown person that a Porsche vehicle, as well as $250,000, was waiting to be given to Mr. Winfrey once he finishes serving time in custody. Now, that is interesting because it seems like this person, it's a jail phone call. They were waiting for $250,000. I wonder if it was cash. But the crazy thing about this is that this person is alleging that that they were supposed to have this money. But the prosecution played this jail phone call, and Judge Glanville in that moment allowed the jail phone call to be played, right? The prosecution theorized that the vehicle that had the money in it, and let me just make sure that I open a new tab. Let me make sure I bring you guys back up to speed so you can follow along. Here we go. We are back up. The prosecution theorized that the vehicle and the money were rewards for Mr. Winfrey's silence not to speak with law enforcement about who, if anyone, was supposedly the person or persons responsible for the April 26th tour bus shooting involving Lil Wayne and other gang-related crimes. So here we have a link to the jail phone call that runs from 4850 to 56. It looks like it's about a 6-minute jail phone call. I will play it for you guys after this. So let's get through the document and we'll listen to it. But that's what Brian Steele's starting with, is that this jail phone call was played. It involves a Porsche and $250,000 to the person that did not snitch, so to speak. So I want to listen to the jail phone call, but let's keep going to see what Brian has to say first. Then, to date, and based upon information and belief, Rashad and the other unidentified/unknown person, as well as Mr. Winfrey, have not and will not testify at trial. Undersigned counsel does not know the identity of Rashad or the unidentified person, and therefore cannot locate, interview, or call any of these persons as witnesses. Oh my God, that's a big problem. That's a big problem, guys. Brian is basically saying that the prosecution was allowed to play a jail phone call and talk about what the contents of that phone call, which included a Porsche, $250,000 given to this gentleman named Rashad, and almost like a thank you for not snitching type of thing. But this paragraph 2 right here says that the state has not identified where this person is. He has not testified in trial. But why? Like, red flag for me is, why was this phone call allowed to be played? And I'm guessing that Brian objected to this phone call being played. But it was allowed to be played. So just keep that in mind. It was allowed to be played. Now, let's go back in to see how Brian finishes off that thought. He says, Mr. Winfrey is a severed, in custody, co-defendant, and, based upon information and belief, has and or will exercise his constitutional right to remain silent. After playing this above reference recording for the petite jury, admitted into evidence as a state's exhibit number 140EAB. The prosecutor questioned witness agent Ricey and elicited that within approximately a month of this recorded jail call, Mr. Winfrey pled guilty to indicted charges in Cobb County. Looks like we have another link to a YouTube video here that was dated. I wonder if it's the same one. It is the same. It is the same one. Okay, so that YouTube link is the jail phone call, and it just looks like Brian is linking something between the 56-minute mark and the hour and 3-minute mark. The prosecutor's clear import of this testimony is to persuade Mr. Williams's jury that shortly after being promised this vehicle and money, Mr. Winfrey accepted responsibility for this crime in order to show loyalty to the supposed gang. Thus, Mr. Winfrey did not fight his then pending Cobb County. We'll see what the next thing says. I think it's charge. And there's a footnote here. It says a thumb drive of all the attachments, YouTube video and audio, is also filed with the clerk, the court clerk, and given to the court reporter and prosecution. So it was provided. Let's now go on to see how this ends. And guys, you know, we are looking at this in images, and I am getting this from Twitter. So I apologize that we're having to do that instead of looking at the full document. But let me open image in new tab. Okay, we're going to go to the next page. Let us share screen. Perfect. Let's go on to the next page. So it was a Cobb County indictment by proceeding to trial, and instead sat mute in prison because he sacrificed himself for the betterment of the supposed YSL gang by entering this guilty plea. On Tuesday, May 14th, lawyer Hilton and everyone connected with this case knew or had a duty to know that Mr. Winfrey's guilty plea entered after this recorded jail phone call conversation was deemed involuntarily tendered. It was withdrawn as the Cobb County Trial Court, specifically Cobb County Superior Court's Judge Stanley, was found to have coerced Mr. Winfrey to enter this guilty plea involuntarily. We have the word coerced. Thus, the involuntary guilty plea was not knowingly, freely, intelligently, and voluntarily entered. Looks like there's an exhibit and there's some case law there. In reality, this above reference recorded jail call had no impact on Mr. Winfrey's decision to plead guilty as to the truth of the matter. As the truth of the matter is that Mr. Winfrey was desirous to go to trial. In fact, on the date of tendering this involuntary guilty plea, Mr. Winfrey maintained innocence and intended to exercise his constitutional right to a jury trial until the trial court coerced him to enter this involuntary plea. Sorry, guys, I can't talk today. Starting to get tired. Based on the above, the prosecution has manipulated facts and put forth knowing false information before the jury. Undersigned counsel immediately objected to this questioning by lawyer Hilton. So he's saying, I objected. And responses of Agent Racy and at a bench conference told the court that it was wholly shocking, untruthful, and misconduct for the prosecution to knowingly use a coerced and involuntary guilty plea against Mr. Williams at trial. The court denied the undersigned counsel's request for any relief or admission to the jury for the jury to ignore, exclude, and remove any testimony regarding this month later guilty plea. Further, the court ordered undersigned counsel not to cross-examine Agent Ricey on this false and misleading topic wrongly introduced by lawyer Hilton. Okay, let's break that down. I thought that maybe he was going to go in with something related to Woody, but what's actually happening here is Brian Steele objected to them playing this jail phone call, right? And he told the court that it was shocking, untruthful, and it was misconduct for Simone to knowingly use a coerced involuntary guilty plea against young Thug at trial. So what Brian is saying here is actually, it is a little shocking, but I'll be honest, guys, I'm not really surprised at this point. There is another coercive conversation that took place with a witness in this case. That's what he's saying. It looks like someone took a plea deal, but that person didn't want to take the plea deal. And it is alleged that plea deal was done under coercion. Again, so we're seeing a lot of allegations of coercion here, right? We're seeing a lot of that in these court filings. And it really is interesting. Let's see how this argument shakes out, because I don't think anyone foreseen that coming in, because we're now going to this May phone call, right? So let's see how Brian finishes this up. We're going on to the next page. We're turning the page. Okay. Later in the trial day on Tuesday, May 14th, undersigned counsel made an attorney proffer concerning his desired cross-examination of Agent Ricey, since the court ordered undersigned counsel not to cross-examine Agent Ricey on the topic of this coerced involuntary guilty plea, the Supreme Court's opinion in Winfrey v. State. The fact that Mr. Winfrey wanted a jury trial, that lawyer Hilton's use of this coerced guilty plea was misleading and introduced knowing impermissible testimony, that there was Cobb County judicial misconduct that birthed Mr. Winfrey's involuntary guilty plea in 2015. Whew, guys. Brian is coming out here and he's saying that Simone coerced this man to a guilty plea, to plead guilty. And she's using information that was obtained through that guilty plea. And that's really essentially what Brian is saying. He was saying that it was improper for us to use that evidence. We have a coerced guilty plea. And this is kind of coming not out of nowhere, because we've been dealing with the whole judicial misconduct thing. But Brian filing this right now, I think in a way is a tad bit strategic, because in a good way. And I say that because right now everything is halted. The title of this video is that the court proceedings are halted. And I wonder if this is something that was looming before he was almost held under contempt and, going through all these things over the last few weeks, that, maybe this is something that was just kind of on the back burner while we were dealing with the primary thing. But at the same time, when you see the repeated words of coercion and getting some of these folks to take guilty pleas. And you guys were here with me on Friday. We watched some of these other defendants similar to this man, who they were severed from the ultimate larger RICO case, right? So it is interesting that this is coming up now, but let's keep reading and see where Brian lands. Because of the court's order, undersigned counsel forfeited his cross-examination of Agent Ricey regarding the accuracy and completeness of his testimony, and undersigned counsel was prevented from correcting the prosecution's intentional use of coerced, withdrawn, vacated, involuntary guilty plea. Undersigned counsel intended, and this is Brian, he's talking about himself. Undersigned counsel intended to cross-examine Agent Ricey to challenge this above referenced trial testimony and use the transcript of the Cobb County November 20th involuntary guilty plea. See Exhibit B, where there was a coerced guilty plea transcript. Admit a copy of the opinion of Winfrey v. State, whereby the highest court held that the guilty plea was not voluntary. Further, undersigned counsel intended to call the 2015 trial lawyers for Mr. Winfrey into the Cobb County indictment. Oh man, this is getting deep, guys. What is Brian saying here? Brian is saying that he intended to cross-examine the agent, Ricey, to challenge this trial testimony, right? So Brian was like, you didn't give me a chance to cross-examine this agent. Why did I want to do that? I wanted to do it to talk about the involuntary guilty plea, right? Why? Because I was going to use the opinion of Winfrey v. State, where the highest court, the Supreme Court of Georgia, held that the guilty plea was not voluntary. So Brian had information that he wanted to bring in, but he wasn't able to do that because he wasn't able to cross-examine the person that we're talking about. Further, Brian was about to bring in the trial lawyers that were involved in the Cobb County matter, the Cobb County indictment. So Brian's like, hey, I wasn't able to cross-examine this person. Here are the things that would have been under discussion. Here are the pieces that would have been able to link to it. And I wasn't able to do that. And here's the other thing. There's a coerced guilty plea, and we need to talk about that, right? So I'm just going to refresh here. Those are the first 4 pages of the document, guys. We're going to do the first 8. So we've done the first 4. Let me go back in just to make sure the document's not ready. We've done pages 1 through 4. Here is page 5. And again, sorry guys, the full document isn't exactly uploaded yet, but let me go to page 5 for you. Okay, page 5. Lawrence Zimmerman Esquire, as well as the Honorable, this is the Manny Aurora Esquire, to explain the conduct leading to the entry of the above involuntary and coerced guilty plea and their observation during this coerced guilty plea. So he was going to bring in 2 attorneys that were there, These two trial lawyers that were there. So, and I apologize, guys, my window is open and there's a baby next door crying. So sorry if that's coming up on the mic. But anywho, they were hoping to get those, he was hoping to get those observations from these two lawyers and bring in their opinions. Also, Brian intended to call Mr. Winfrey's appellate lawyer in Winfrey v. State, the Honorable Steve Sadow. Oh my God, guys, it's Boots. So Boots was involved in that case. I don't know if you guys know who Boots is. I call him Boots just, you know, kind of as an observation. Steve Sadow is Trump's attorney. We were just talking about him last week. Steve Sadow is highly respected in the Georgia area. He is Trump's attorney in the election interference case. We just looked at one of his documents last week that was filed in the matter with you know, Trump and Fannie Willis and all of those things. You know, I had no idea how well connected Brian was. He was going to have Steve Sadow come in on this. And I believe there was a Steve Sadow sighting at the courthouse with the YSL trial recently. So this is interesting. So Steve Sadow was going to come in to testify about this coerced guilty plea, as well as the August 7th Alford plea, wherein Mr. Winfrey maintained complete innocence and only entered an Alford plea because he received a time-served sentence. Okay, so there's some case law. These exhibits are very important, guys. I actually now want to see the full 114-page document. All of the above would permit the jury to intelligently consider whether the October 15th vehicle money recorded jail call had any impact on Mr. Winfrey to forfeit his right to trial or to silence Mr. Winfrey not to cooperate against Young Thug and others. This truthful evidence would also unmask the prosecution's team's use of untruthful testimony. Instead, Brian has been denied Mr. Williams' right to defend the case, introduce evidence, confront witnesses, and have a fair trial and right to due process. Mr. Williams has been denied his constitutional right to present his defense. He has been denied his constitutional right to cross-examine on this relevant material issue introduced at trial by lawyer Hilton. Young Thug has been denied his constitutional right to a fair trial. Young Thug has been denied his constitutional right to correct the testimony, his constitutional right to introduce highly probative evidence and call witnesses at trial, his due process rights, all under the below provisions of the United States Constitution and the Georgia Constitution. In Holmes v. South Carolina, there's a case law there. The United States Supreme Court held that whether rooted directly in the due process clause of the 14th Amendment or in the compulsory process clause or the confrontation clause. Oh my God, he's cooking. Steve Sadow got introduced to this. We're talking about Young Thug being denied some of these rights. This is interesting, guys. Oh my God, it's going down. Let's turn the page. It's like a book. It is like a book. Let us turn the page and go to page 6. Here we go. So, whether he has been denied his Sixth Amendment, the Constitution guarantees criminal defendants meaningful opportunity to present a complete defense. This attorney proffer is made to ensure that these topics are properly preserved. A mistrial should have been and should be declared because upon this court's ruling that denied Young Thug's constitutional right to cross-examine, his constitutional right to present a defense, his constitutional right to call witnesses, his constitutional right to a fair trial, his constitutional right to due process. Judge Glanville, guys, his order to release the ex parte transcript has been filed. So I'm going to quickly read through this. We're going to go to that. You are in the right place tonight. I'm giving you guys heat. We started with Doug Weinstein. We're going to this Brian Steele cooking document. And I believe that we are now in a place to take a look at the order of the transcript. I don't know if the transcript is attached and available with it, but we'll look at that in a second. And thank you guys so much for sending cash apps. It looks like it was just filed at 7:27 p.m. on the East Coast. I have time of 7:47, so about 20 minutes ago, the document was filed. And same thing, it looks like we have some images on it. So here we go. We're gonna take a look at it. According to the footnote in that, and let me take this down for a second so you guys don't get confused on what I'm talking about. I'm talking about the transcript that Judge Glanville said was going to be available today. He has the order that's coming out. According to the footnote, it says the actual transcripts will be filed separately. I'm just looking at it. Okay, it does say the court's exhibits identified in this order will be filed into the record separately. The list of exhibits is followed. We will get the transcript of the June 10th conversation. Ooh, we're going to be able to look at Little Woody's immunity agreement. We're going to be able to look at the June 7th in court proceedings. We're going to be able to look at the order of contempt and incarceration of Little Woody. We're going to look at the transcript of all in court proceedings for June 10th. And we're going to look at the order of contempt for Brian Steele. We've already seen that. The court notes that some of the time stated in this oral ruling may be in open court on July 1 were incorrect. Oh my God. Okay, that's a whole nother thing. It looks like Judge Glanville is correcting some things he said today. Back to Brian. Back to Brian, because this is all happening at the same time, guys. Like 2 documents are being filed. Let me go through this one. We're almost done with Brian's document here, and then I will bring up what we have as Judge Glanville's order for today. Okay, so going back to this, I'm just going to go to the top. This attorney proffer is made to ensure that these topics are properly preserved. A mistrial should have been, and should be declared based upon this court's ruling that denied Young Thug's right to cross-examine, his constitutional right to present a defense, his right to call witnesses, his right to a fair trial, and his right to due process. Brian Steele proffer continues. On Friday, June 7th. Oh, here comes Lil Woody. Here comes Lil Woody. On Friday, June 7th, witness Copeland, Little Woody asserted the Fifth Amendment in front of the jury. That should never have occurred, as based upon information and belief, the prosecution team, as well as this court, knew that Little Woody was going to do the same before Little Woody was called to testify in front of the jury. Before same occurred, Brian Steele did not know that it was Little Woody's intent to refuse to answer questions in front of the jury. Once Mr. Copeland invoked his constitutional provision, undersigned counsel immediately moved for a mistrial, which was denied. The court then denied Young Thug's counsel's request to call witnesses to prove that the prosecution team knew that Little Woody intended to invoke the Fifth Amendment in front of the jury if/when he was called to testify by the prosecution. Undersigned counsel desired to call Fulton County District Attorney Investigator Long and Lieutenant Liz Lansiquette, who is employed by the Fulton County District Attorney's Office, to memorialize their knowledge that Little Woody expressed that he would invoke the Fifth Amendment in front of the jury. Moreover, undersigned counsel intended to call reporter George Sheedy to testify that he was ordered immediately prior to Mr. Copeland taking the witness stand and refusing to testify, not to video Mr. Copeland if and when the court ordered him to be arrested for contempt. Oh my God. Wow. So what does that mean? And I'm sorry, I think I have confused the words undersigned counsel and replaced it with Brian Steele. I think when he's saying undersigned counsel, it's referring to Simone Hilton. So Brian is saying that the prosecution team is making it seem like they did not know that little Woody was going to invoke his Fifth Amendment right to clam up essentially and plead the Fifth. It looks like they knew here. That's what this document is saying. It looks like they knew. And we are talking about folks from the district attorney's office, Investigator Long and Lieutenant Lancequat. I hope I'm saying that correctly. He was also employed by the Fulton County District Attorney's Office to memorialize their knowledge that little Woody expressed that he would invoke the Fifth Amendment in front of the jury. So this is bad. This is showing that they knew he would plead the Fifth, that two people were willing to memorialize it, meaning they were willing to sign something. So that means that like people knew that little Woody was going to plead the Fifth before he got on the stand. Oh, this is getting good. This is getting good. And then we also have instructions. The reporter, George Teedy. So there's a reporter in the courtroom that was instructed that they cannot take any footage of little Woody being arrested after he pled the Fifth. What is going on here? This is page 6 out of 8. Let's go to page 7. Turn to page, AV. Let's go. Okay, Judge Glanville just released the transcript, guys. All right, let's finish up Brian still real quick. We're going to do these 2 pages. We're going to go to the order and let's go to the transcript. Let's go. Let's go. Wow. Today is like the craziest news day in the YSL trial. I'm so happy you guys are here with me. I think I'm going to text Lee to let him know too that the transcript is available. We're going to talk to Kayla Bumpus with this and look at it. Transcript out. I'm letting him know just in case he wants to go live on his side. This would be a really double duty day, guys. Okay, so they could not film little Woody's being arrested for refusing to testify. Let's bring this back up. Based upon information and belief, reporter Cheedy was given this edict by the Fulton County District Sheriff's Office deputies based on an order of this court. If true, this court had knowledge that little Woody would likely refuse to testify in front of the jury once called as a witness. So this is from the Atlanta Objective. This is an article by reporter George Cheedy, dated on June 11, 2024. Guys, you want to know what Lee said? He said, damn, it's going down tonight. It really is. It really is. It is. Oh my goodness. There's so much here. Okay. From whom did the court receive this information? I love Brian. I love when Brian puts questions in here. He's like, from whom did the court receive this information? Why did the court not reveal the same undersigned counsel before permitting little Woody to testify before the jury? Did Attorney David Botts announce in open court that before little Woody took the witness stand, little Woody uttered in close proximity to members of the prosecution team that he would go to jail and would refuse to testify before being called as a witness before the jury? When Attorney Botts announced this proffer to the court, this court stated that it had a problem with Attorney Botts. The blame belongs to the state for calling little Woody, knowing or having reason to believe that he would refuse to testify in front of the jury. The same blame is attributed to the court if it knew the same information before little Woody testified before the jury. Go. Can we get an amen, Brian? Mr. Williams and his counsel were in the dark about little Woody, making it clear that he would refuse to testify in front of the jury. This court did not permit undersigned counsel to call any witnesses to support his timely voice motion for mistrial. Hence, this proffer is hereby in place. Moreover, oh, there's more. Brian with the T. Moreover, on April 29th, during cross-examination of Detective Gaither by the Honorable Max Sharp, counsel for Mr. Stillwell, Detective Gaither improperly injected her expert opinion that the criminal street gang YSL committed a shooting of another person. Immediately, undersigned counsel objected and asked for a mistrial. And at a bench conference, oh my God, we got to turn the page. Oh my God, this is the last page. This is the last page. Ooh, this is the last page, guys. I cannot wait. This is getting good. We're gonna, okay, open image, new tab. All right, present, share screen. All right, let's go. The court found that the demeanor of Max Shart gloated Detective Gaither, giving this unsolicited, prejudicial testimony in front of the jury. Sorry, guys. I'm at family's house and they are incredibly loud. They gloated Detective Gaither into giving this unsolicited, prejudicial testimony in front of the jury. As proven in the trial audio/video, Attorney Shart never gloated this improper, prejudicial testimony by Detective Gaither, and therefore the court's observations to perfect the record are hereby challenged. Wherefore, this attorney proffer is made to correct and supplement the record this first day of July. Signed, Brian Steele from the Steele Law Firm and Keith Adams, his co-counsel. It is going down tonight. Well, ladies and gentlemen, let's go back. Brian has, I need time to digest that, and he's included a lot of links in there. So I will absolutely be checking those videos out tonight and handing them to my editors because I think it would be good. So as of 7:45, it appears that we do have the entire transcript. Well, not the whole thing. The transcript has been filed and is in the process of being uploaded. So it's not exactly available right now. But while we wait, I will show you the order that Judge Glanville filed. So he stuck to his word. He provided his order that he mentioned at around, I think it was around noon today. So that order has been filed. That went in at 7:27. And as of 7:45, so about 15 minutes ago, the full transcript has been uploaded, but it's really long. Let me show you what I have on the order. So let's look at the order that Judge Glanville filed today on the order for the document. So we have the state of Georgia versus everybody involved in the case. Here's the order. It says the above style case is currently before the court and its decision to release the entirety of the transcript of the June 10th, 2024 ex parte conversation involving the state's witness, Mr. Kenneth Copeland, Little Woody, for review by all interested parties. In consideration of the court's release of the transcript in its entirety, the court takes judicial notice of the following timeline of events. So this is the timeline, guys. Let me just send a quick text. So here's the timeline that we talked about, and I took notes earlier while we were in court listening to this, right? So the morning of June 7th, upon notice from Little Woody's attorney, Jonathan Melnick, that Little Woody is considering pleading his Fifth Amendment right against self-incrimination, the attorneys for the state seek and receive an immunity order for Mr. Copeland to ensure his testimony, right? Then in the afternoon, Mr. Copeland takes the witness stand, and after evasively answering the question, he pled the Fifth Amendment right against self-incrimination. The court holds Little Woody in contempt and has taken him into custody. This is that footnote I was reading on my phone, guys, here on the bottom. It says the court's exhibits identified in this order will be filed into the record separately. Here is the list of exhibits. So they're going to put in 6. 1 is a transcript of the ex parte communication. 2 is Little Woody's immunity agreement. 3 is a transcript of the June 7th in court proceedings. 4 is the June 7th order of contempt and incarceration of Little Woody. Hold on, guys. 1 second. Let me just mute this and tell my family to stop being so loud. I'm sorry, guys. Sorry, I'm like, a lot of people can hear you. Shh. All right, guys. So that's really the list that we're looking for, right? Now let's go to the next page because we have 2 pages of this order. And it's very telling because he's going through the timeline a little bit and we're able to look at that. So open a new tab. Here we go. Share screen. Boom. There we are. In deciding to release the entirety of the transcript of this ex parte conversation, the court takes judicial notice of the allegations asserted by Mr. Steele in open court on June 10th and which are contained in the June 10th transcript. In particular, the following allegations are pertinent in this decision. And it looks like there are about 6 of them. First, that little Woody was goaded into meeting with the court and attorneys for the state, ex parte. Oh my God, Glanville's going rogue, guys. I can already see it. What the hell does goaded mean? Define goaded. Goaded, past tense, to provoke or annoy, so to stimulate some action or reaction. What? Okay, define goaded. Yeah, goaded in legal terms. Okay. Goaded from the legal terminology means to urge or force someone to do something. Okay. So it says that one of the allegations is that little Woody was forced into a meeting with the court and attorneys for the state. 2, Judge Glanville also says that little Woody asserted that he was going to plead his Fifth Amendment right against self-incrimination. That little Woody was a party as a sworn witness, and that the defense had the right to be present at this ex parte communication, as it was a critical stage of trial, according to Scudder v. State. That little Woody indicated he was not going to testify and that he would sit in jail for 2 years. That the ex parte conversation improperly involved coercion and witness intimidation by the court and attorneys for the state to force little Woody to testify, and that little Woody admitted that he was the one who killed Donovan Thomas. We all want to know that. We're all like, what happened with that? Right? So that's the order. Okay, that's all that they have on that one, aside from the original document. But guys, it looks like we have some really good stuff for you tomorrow. Oh, I have the full transcript. Oh my God, I got the full transcript. Are y'all ready? Let's just go in. Sorry, we're doing it. We're going to go another 2 hours if we have to. Here's the full transcript. It's 56 pages. Hold on. Let me just say, do you want to do it now or tomorrow? I'm asking Lee if he wants to do this on his side, but we're here, so we're going to get a sneak peek. Let's go. Here it is. Here it is. Here is the transcript of the secret meeting, guys. All right. In the chambers of Honorable Judge Glanville on June 10th, 2024. Let's go. This comes from Christina Weaver. This is the woman that is she's like the court transcriber, the court reporter. Here we go. On behalf of the state, you had Adrian Love. On behalf of the state, you had Simone Hilton. On behalf of little Woody, you had Kayla Bumpus. All right, so we have 3 people so far. The ex parte hearing began at 9:10. Present in chambers were Judge Glanville, ADA Love, and attorney Kayla Bumpus. Court reporter Christina Weaver, and investigators Antonio Long and Rashid Hamilton. Court reporter, okay, I'm ready whenever you are. Miss Love, thank you. The concern that we wanted to bring to the court's attention as the state was twofold. 1, we wanted to have the opportunity to impress upon Mr. Copeland with representation present that he faces, and we wanted to give him an opportunity to ask whatever questions he wanted to ask before he was we had to pull him in the courtroom when the jury came out. The second concern that I have is and I wanted to bring to the court's attention in line with the concern that I expressed on the record on Friday. I don't know what advice counsel may have offered or may be offering. That is their right, and it is their business, which she's talking about Melnick here, right? She's talking about Melnick. As it relates to testifying, however, I do not believe that criminal exposure is a concern that is which interest is being spoken about and protected. Mr. Melnick relayed to Ms. Hilton on Friday that he had never heard of the statute 245507, and on Friday he sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Sharp. I don't know if he unintentionally put my name on it. But he sent an email to Mr. Steele and Mr. Sharp with me and Simone copied, where he said, "This is the communication that I received from Miss Love regarding Mr. Copeland." My response was, and this is Miss Love talking, "Whose interests are you protecting, yours or Mr. Steele's? Whose clients, which client are you protecting? Whose clients, yours or Mr. Steele's or Mr. Sharp's?" He wrote back and said, "You are going to have him killed. You have made him, you are making him a target. Fuck you." That is what he wrote in an email. Yo, guys, hit the like button. This is tea. Now we're figuring it out. Oh my God, let's go back in. I'm making me small so y'all can read. Wow. So given that his concern is that by testifying, at least the one that he conveyed to me in writing, it's not his concern, has nothing to do with the exposure from the state. And if it is his concern, the court, this is Judge Glanville coming in, he says, his being whose concern? Miss Love, Mr. Melnick. If the interest that he is protecting little Woody's freedom, he did not convey it by asking us what exposure does he face in testifying. In fact, if he's concerned that testifying will get Mr. Copeland killed and he is not communicating with us, he's communicating with counsel for the defendants. It would seem that he knows a thing or something that we don't know. Additionally, and I will let Miss Bumpus tell you, he said if little Woody testifies, he's no longer representing little Woody, which is strange because if your interest is your client, then it would seem you would want to be there for him while he is testifying. Guys, teapot, forget teapot. Love said that's why Melnick was all flustered that Friday. I showed it to you guys. I showed you guys the clip. Allegedly, he was going on vacation, had everything already booked. But it sounds like he actually did care about little Woody. Like he didn't want little Woody to get killed. He's just like, by you doing this, you're going to get him killed. Fuck you. I mean, I'm sorry to say it, but whoa. Let's go back in. Oh my God, this is so crazy. Judge Glanville says, well, he is on vacation this week. Miss Love says, I understand. That's why he has Miss Bumpus here. And he has said what he has said. And as I was reading the statute, I was reading the statute about this particular situation, and I was reading our rules, our ethics and our rules of conduct for attorneys. And it is clear that if an attorney that were two things that were happening. One, Mr. Melnick had told me he wasn't little Woody's lawyer. Little Woody had told Miss Hilton that Mr. Melnick wasn't representing him. And then rather than little Woody reaching out to Mr. Melnick apparently was in communication with Mr. Steele, Mr. Sharp, and Mr. Melnick reaches out to little Woody and injects himself in these proceedings. What we were discussing was in no way a matter that Mr. Melnick was representing it was a matter that Mr. Melnick was representing little Woody on. And that is where we are not allowed to speak with the person when they are represented by counsel. Mr. Melnick was not could not have been representing little Woody on anything we were talking about, because we were talking about this case and this trial. All of that aside, we would like an opportunity for the court to address little Woody with little Woody's stand-in counsel present, Miss Bumpus. It says Miss Bumpus is looking at me like, and this is when Kayla jumps in. She said, I'm listening. Shout out to Kayla. Miss Love says, with his stand-in counsel present and to allow Miss Bumpus an opportunity to explain to little Woody everything that I have just said. Her concern outside was what is the longest he can stay in jail. Kayla told me and Lee that earlier. What I relate to her is the statute says until he purges. Judge Glanville jumps in. He says, by testifying. Miss Love goes on to say his contempt by testifying. Judge Glanville, yeah, 507 is a little bit different. So, I mean, Miss Bumpus jumps in. Shout out to Kayla. She says, so until the end of this, Glanville says he can be here until the end of the trial. Damn. Okay. Miss Bumpus, that is what I said. To the end of the trial is the longest. Miss Love, no, it's not the longest. Even after a grand jury, if a person has been subpoenaed to testify before the grand jury, and even after the grand jury has, convened, has left, that person can stay in until the person purges themselves of contempt by testifying. The statute literally says that. Kayla says, well, I'm going to look it up because it was my understanding that it was until the end of trial. This is what Kayla was talking about with me and Lee. They made it seem like little Woody would be in jail forever, indefinitely, right? Miss Love says, nope, here it is. Literally the words of the statute. And so Glanville jumps in. He could be in there a while. Let's put it that way. Either way, Kayla jumps in. I just want to be able to give him. Glanville jumps in. I know. It's kind of the statute. Says, that you purge, but I can't keep him in there indefinitely. I've got to Kayla says, right. That is all I want to know. Glanville says, the whole thing is that he has the keys to his own freedom. And that freedom is if he just gives his testimony, then he's purged it. Kayla says, right. Miss Love says, and whatever that testimony is, we know what we believe it to be. But, we don't know what it is. We can't talk about it. We don't. We don't know what he's going to say. We have an idea. We know what he's told us. Kayla says, yeah. Miss Love says, and our concern is that our concern, I know the court said essentially you intimated that you, Mr. Melnick, probably told him essentially you should testify. They are not going to. They can't do anything with your testimony. But what we overheard being said was they are going to hammer you as if we are going to expose little Woody to. Kayla jumps in. You heard that? Miss Love says, yes, yeah. Mr. Melnick told Mr. Copeland, little Woody, we're going to hammer him. Glanville jumps in. Now, to be fair, and I think Miss Bumpus has an advocate or anybody has got to tell him he's going to face some pretty significant cross-examination. Kayla, yeah, I think that's what he meant. Glanville, he's got about 10. Miss Love jumps in. So he meant the defense is going to hammer him. Miss Bumpus says, no, just in general, it's not going to be a, hey, da. Shout out to Kayla. Miss Love says he knew that. He had literally been expressing that. Glanville. But I think that if he's concerned about that, but it's all in the message and the packaging in terms of, I think Mr. Copeland is, a savvy person. But, he's certainly going to be subject to a thorough sifting cross-examination. Miss Love. And the other thing is that, Miss Bumpus, can I just say something in Attorney Melnick's defense in response, just for the record? Oh, Kayla was hip. Kayla's like, what's going on? Miss Love says yes. Kayla says the reason he doesn't want to move forward with representation, that I have been told, if he decides to testify, is that he doesn't feel like he can. He doesn't know what was said outside of his presence. So he doesn't feel like he can adequately represent him or counsel because he doesn't know what was told to the state when he wasn't there. Miss Love. But the thing is that the only thing that he should be concerned about is the criminal exposure, or the exposure that little Woody has criminally. And there is nothing. There is literally nothing. The statute is quite clear that we can do to him about only the thing that would put him in harm's way is a lie and a refusal to testify after being ordered to do so by the court. And by a lie, we don't mean like, oh, I think you lying, it would have to be, something obvious, because he can always impeach. We can always impeach. But if he literally perjures himself, and that's something different, we can't help that. We can't control that. We would have to say, tell the truth. I don't care how bad it is, just tell the truth. So, he's like he says, I didn't go down to the police station. Here's Glanville. And I think part of this challenge, Miss Bumpus, may be that you need to assure him, look, I'm going to be here. And if you think that they are asking you a question, they being the state or the defense is asking you a question that's going to bring out other crimes, that he's going to have to be able to look at you and say, can I have a chance to talk with you? Miss Love says, that's exactly right. Kayla says, uh-huh. Miss Love says, see, but that's just it. Kayla says, no, he's not. Miss Love says, hold on. But that's just it, Judge. The problem is that there's been an assertion that people are representing, and I'm not talking about you. Kayla says, yeah. Miss Love says, there's been an assertion that people are representing that are not their biggest concern is his best interest. And then they are just not here. And Miss Bumpus is saying she's not in the position to do that. Kayla says, no, I'm not saying I'm not in a position. I'm saying that the agreement between Mr. Copeland and Melnick, who I'm standing in for, is that if he chooses to testify, I'm to get him to sign this paper that says that then discharges Melnick as his rep. That's their agreement. I can't do nothing about that. Miss Love says, that sounds weird. That does not sound like something in little Woody's best interest. That sounds like protecting someone else's best interest. If you talk, I'm not going to represent you. I don't even know what to do with that. Kayla says, well, he said he does not know what was said. Miss Love says, it doesn't matter what was said. Kayla says, right. Miss Love says, it doesn't matter. And he didn't ask us. He didn't even inquire. What have you all talked about? He has been talking to Brian Steele and Max Shard. That's it. He is not talking to us. They're talking about Melnick, guys. And in fact, when little Woody asked to speak with us, Mr. Melnick barges in and gets in between Miss Hilton and little Woody and literally keeps us from talking to him before he gets called on to the stand. And that's troubling. Oh, man. Do y'all see where this is going? They're trying to make it seem like there is this scheme between defense counsel by Melnick getting involved and only talking to Brian Steele and only talking to Sharp. Now I understand what was being protected. Miss Bumpus. Well, I think what happened was, and I say this because I previously represented little Woody previously on his other stuff. So I don't know when this is just what I think happened. I think how Attorney Melnick came involved was his representation of because he took my place. Little Woody fired me and hired Melnick, and then this came about. And I think, so at the beginning, Melnick was representing him, and then Miss Love chumps in, in his criminal matter that he had. But that's resolved. Kayla says, but when this case started, Melnick called me and told me that he was representing him as a witness at the beginning. I can assert that. Miss Love, Melnick has never in life. Miss Bumpus, this is 2 years ago. Miss Love, Melnick didn't, as a matter of fact, less than 2 years ago when Copeland was sitting in jail for something else he had done. Melnick said, I don't represent him. He told me I don't represent him. And people were in the room. He was on speaker. He told me he didn't represent him. Now he ultimately did come about and represent him. But when we were trying to get, I guess, Kayla says something, yeah. Miss Love says, Copeland was like, he's not my lawyer. I don't have a lawyer. He's not my lawyer. And then Miss Bumpus says, are you talking about recently? Miss Love says, so recently, Little Woody said that Melnick was not his lawyer. Miss Bumpus said, right. Miss Love says, when Little Woody was in jail, Melnick told me he wasn't his lawyer. But our understanding was that Melnick was his lawyer for those criminal charges. And so the person that came in and argued, or at least stood in for him on his bond and then on his subsequent plea was Melnick. But I don't know whose interest he would be representing when he's not talking to us about what we've spoken to Copeland about. He could ask us and we would tell him, so I don't know why he would withdraw his representation of him. If his interest is Little Woody, then why would you pull out? Ooh. Judge Glanville says that doesn't make sense. Miss Love says at the point where he would face the most peril, if that is his concern. If his concern is, I don't know what they've talked about, so I don't know what. Glanville says, I thought that Miss Hilton had a list of questions for Mr. Copeland anyway. Miss Love says she did. Glanville says, well, how come you all can't? Miss Love, he didn't ask to see those. He didn't. And not only that, Glanville says, well, can't you all share that with Miss Bumpus? Miss Love says, well, Miss Hilton has already shared it with Mr. Copeland, and we certainly will share it, generally speaking. Miss Bumpus says, can I read this email that Melnick sent me? I don't know if this will help you understand what he's saying. Oh, it says, hey, Kayla, I wasn't able to see Kenneth today. Kenneth is Little Woody. He went on Saturday and tried to talk to him before his flight, but I have talked to his family. So at first, Little Woody was going to testify, but now has decided to take the 5th. He may change his mind on Monday. If he does, then he's agreed to discharge me as his attorney. This isn't out of bad feelings, but I was not present when he met with the DA's office, so I can't really help him with his testimony. And then he gave me the discharge and told me that if he decides to testify, then he's to sign this. Miss Love. And that's just it. It's like you never know what somebody's going to ask. And if he's concerned about putting him in legal jeopardy, then it would seem like he would remain and allow Mr. Copeland access to counsel when Mr. Copeland is concerned that he's about to walk into an area that puts him in legal jeopardy. Miss Bumpus, you can't switch how he gets called. Miss Love, see, that's not in Mr. Copeland's best interest. That's in the defendant's best interest. When you say switch in how he gets called, what does that have to do with anything? Kayla says, I don't know. Maybe he's saying he can't do it because he can't get his refundable ticket. Miss Love, that is not what he said in that email to you. And that is not what he relayed to the court. And his concerns have nothing to do with, Glanville says, he was very much, Kayla says, I try to go back and watch as much as I could. Glanville says, telling me what he was, that he was going on vacation. And I said, well, you inserted yourself into this. And I said, really, you need to come on Monday. Miss Love says he can't force Mr. Copeland to discharge him just because. Okay, let me read that again. Miss Love says, so he can't force Little Woody to discharge him just because Little Woody decides to testify. Glanville says, I think you are in until it's done. I mean, Glanville looked at Kayla and said that. And she said, who, me? Me? I'm in it? After meeting her, now I can see her having this reaction. Glanville says, yeah, I mean, that's just if he testifies. You've got to kind of, Miss Love says, and frankly, Your Honor, I know that if a person faces criminal contempt, they are entitled to representation if they want it. This being a civil contempt matter, Glanville says, not necessarily. Anyone who's facing contempt can get counsel. I mean, not anybody, but Kayla says, I can't stay. How long is this going to take? Miss Love says, it might take some days. Miss Bumpus says, uh-huh. Miss Love says, and see, that's just it. And I don't mean, I think Miss Bumpus is put in as a precarious position. She's not the one that stood up and injected herself into this. They reached out to her. She did him a favor. But ultimately, it seems as if Mr. Melnick is stalling and attempting to delay and hamper and hinder our proceedings. And that it's a problem because that has nothing to do with his best interest of little Woody. And that has nothing to do with little Woody's exposure if he testifies. Just to answer the question about what he's exposed to, the statute is very, very clear. It literally says that no testimony or any evidence required under the court's order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for the crime or offense concerning what he testified or produces evidence under the court order. That is saying even if he got on the stand and said, Glanville says, he started talking about an unrelated crime, which is what the biggest thing I think he's probably thinking about that is that there's a lot of stuff they could ask me about. Miss Love says, right. Glanville says that is not known to a lot of people and that, he could also invoke his Fifth Amendment with the advice of counsel if it was some other particular crime. But Miss Love says, but even that, we wouldn't even, Glanville says, literally, right. But Glanville says, even that, he'll still have to testify. Miss Love says, literally, right. The saw lays? I don't know what that means. The saw lays? I think she meant the law says. See this? This is a court reporter mistake right here. The court says, yeah, I mean, anything he testifies to. Miss Love says, we do this. Miss Bumpus says, okay. And then about the delay or stall, isn't it true or is it not true that he had a leave filed since December? Oh, we're talking about Melnick. Miss Love says, we have nothing to do with any of that. He injected himself into this. Glanville says, yeah. See, the problem is, Miss Love says, he stepped in. Glanville says that when you get involved, I don't know, you have a leave. Oh, so because he got involved with this, guys, because Melnick, according to this conversation, inserted himself into it, they're saying if he was on leave of absence since December and he jumps in to help little Woody, is his leave still activated or active? Anywho, Glanville says, and unless you file that leave into this case, you don't have a leave for my case. Miss Love says, right. Maybe this is a mistake he's covering. Kayla says, okay. Miss Love says, and he did not. Glanville says he didn't have one. Miss Love says, Mr. Little Woody's been a witness and a name on this witness list since. Glanville says, so since he said, well, I represent him, I'm like, okay, well, you don't have a leave that's filed in our case. Kayla says, okay. Miss Love says, so he did this to himself and he did it to you. But we have to, that is just where it is. And I don't know that. That's just where we are. Kayla says, so Judge, you're going to make me stay if he chooses to testify? Oh. Glanville says, I am, because you're his lawyer. You're his lawyer. You're a stand-in lawyer at this point. Kayla says, Your Honor, I don't have a problem with that. I'm not ready. Miss Love, if Glanville, there's nothing for you to be ready about. I mean, here's the thing. I think the only thing you've got to kind of ask him is, look, here is the questions the state is going to ask you. All right. Is there anything else that could hurt you that they may ask you about? And as long as you have knowledge of that, then I think that you are fine, because the state's only going to get into this. Now, the reason you want to know what's going to hurt you is the defendants know more about little Woody than anyone else. So they are probably going to kind of, Miss Bumpus, What about if I say I can't do it? Then Melnick needs to come back, right? Am I going to be in trouble because I was only for Monday? That's what I was told. I was given specific, Miss Love. If Little Woody said, and I don't know what Little Woody wants, it's his choice. Miss Bumpus, can't he say he doesn't want Melnick? Miss Love, he can say whatever he wants. It's his choice. Miss Bumpus. But the judge is saying, Miss Love, I don't think he can be forced to have representation if he doesn't want, need, or say he wants it, because we have done everything to clear him of judicial exposure. He's not, there is nothing he can say. He could lie. That puts him in, Judge Glanville said, peril. Peril. Can y'all type peril into the chat? Because now Little Woody's behavior makes so much sense. This is bad, guys. Oh my God, it's bad. Miss Love says, peril, but he can't talk about a crime that we could then prosecute him for. Glanville, that is involving this or some other place. Miss Love, right? Miss Bumpus, I understand that, but Miss Love, and we can't use his testimony to go find evidence to prosecute him for the stuff he talks about. Basically, he is literally shielded. Miss Bumpus, I would have to agree with you on that. I don't think that that's the concern. Isn't that what you said? Miss Love, well, the court said that. Miss Bumpus, no. I'm saying with Little Woody not testifying. You said you don't think that his concern is criminal exposure, or you do think that is what he's worried about. Glanville, do you think that he's fearful of testifying for other reasons, like for his personal safety? Miss Bumpus, right. And there was Tay just died. Tay just died yesterday. Miss Love, that is what Mr. Melnick said to me in an email I could pull up. He said, Miss Bumpus, but don't you believe that, Miss Love? You're going to get him killed. That's what he said. We ain't gonna kill him. Miss Bumpus, see, I don't know anything about that email. Miss Love, we ain't gonna kill him. I can show you the email, but we're not going to kill Kenneth Copeland. So who is he talking about? So what are you trying to do? Glanville, that is a collateral second and third order effect. Let's pray it doesn't happen. But, and guys, I'm going to read that again. That is a collateral second and third order effect. They're going back and forth on the decision for Little Woody to testify. Melnick wanted to get out of this because he knows if Little Woody testifies, he's putting himself in danger. And Judge Glanville just said, that is a collateral second and third order effect. I can't believe what I'm reading. Let's pray it doesn't happen, but Miss Love, obviously Glanville, first he has to give testimony though. That's what he has to do. He's got to give the testimony, whatever it is, good, bad, or indifferent. Good, bad, or indifferent, I should say. Miss Love, so we would like, with the court's permission, they haven't bought him over, and he was supposed to be the first one up. So I guess they want to get him. They might be over here with him now. Glanville, is he here now? Miss Love, I don't know. Judge Glanville exited the chambers at 9:33. Miss Love, he would like to just go into another courtroom and talk to him. give you a chance to talk to him, and then give you an opportunity to explain to him, the court reporter, we're off the record. Judge Glanville and Mr. Chamberlain enter the chambers at 9:34. So Glanville was gone for about a minute. Miss Love. Miss Hilton has been communicating with him. I'd like to grab her from downstairs and have her come up. Oh, she wasn't in the room the whole time. Love, Kayla, Glanville, court reporter. I think 2 other people from the investigator's office were there. But I didn't realize that Simone Hilton wasn't in the room. Let's keep going. Glanville. Where is little Woody? Mr. Chamberlain. They took him upstairs to the tank in 9. Glanville. Okay. We can bring him out too. Can we, Mr. Chamberlain? Your chambers is being used. I mean, your courtroom is being used. Glanville. Let's bring him in here. Mr. Chamberlain. All right. So let me see if I can get that done. Glanville. Let's bring him in here. Okay? Thank you. We'll just bring him in here. The proceedings stood in recess from 9:34 to 10:03. Miss Little Woody. Oh my God. Entered chambers at 10:03. Also present were Judge Glanville, ADA Simone Hilton, Attorney Kayla Bumpus, Court Reporter Christina Weaver, Investigators Antonio Long and Rashid Hamilton, and Deputy Houston, Deputy McPherson, Sergeant Brown, Sergeant Hall with the Fulton County Sheriff's Department. Glanville. Okay. Little Woody. Can you let him know I got a hearing problem? Okay, in comes little Woody. Kayla says, okay. He said, he is hard of hearing. Glanville. That makes 2 of us. I've got a hearing aid that's coming on the 27th of January. In June. So I'll try and talk loud. Is it okay if little Woody? Yeah, I can read lips. Glanville. Okay, good. Mr. Copeland, good morning. Little Woody, good morning. Glanville. All right. I just wanted to bring you over and let you talk with Miss Bumpus and see if there is anything you need to ask of your counsel or Miss Hilton or the state or the court before we bring you out this morning, because we would like to hear your testimony. And that is kind of where we are at this point in time. So is there anything you would like to ask, little Woody? Well, I want to speak with you personally that I have never been truthful a day in my life until I just made this statement right now. I don't comprehend none of this stuff that's going on. Glanville. Okay, well, the only thing you can give is truthful testimony. Whatever you know is whatever you know. That's it. Miss Hilton. And what we'll say, and Mr. Copeland and we have talked about this. I'm not sure what your concerns are, what concerns you've expressed to Mr. Melnick last week. But if any of your concerns deal with being locked up for anything, you can't. There's nothing that can happen. The feds, Miss Bumpus says, well, that's not. Miss Hilton says, it is true. Miss Bumpus says, no. I said that's not his concern. Miss Hilton says, if his concern is his safety, we need to know that. That's not expressed. So we don't know what the concern is so that we can try to resolve the concern. That is what I'm saying. Mr. Copeland and I have had conversations before. I understand some of his concerns as potential criminal liability, hence why we gave you immunity. The federal statute of limitations, done. The statute of limitations, done. So there is nothing, I researched it this weekend again. Both of those statutes of limitations for what you and I talked about, which is in 2015 or before, done. You cannot be prosecuted for anything you testify federally or statewide. Immune, period. So if that is a concern, there is none. because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything in 2015, 5 years would have been 2020. Anything statewide is 4 years. That would have been 2019. Finished. Next concern, what may happen in the street? You know what we have talked about, what we can do as far as living and all that. We have had those conversations. So I'm trying to express to you that we do not want you locked up. I don't know how many times I've got to tell you what I've got to say to you. We do not want you sitting in the cab or whatever they've got you because of this. I know you wanted to talk to me on Friday before you walked into court. We weren't able to talk. If you still want to talk with or without Miss Bumpus, I'm here, little Woody. But we do not want you in custody. We will not. This order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution, little Woody. Any of it. Literally, Judge, you might want to close your ears. Simone. Judge, you might want to close your ears. If you confess to a murder on the stand and we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in court. Simone just said that. Oh, let me keep going. Oi! Scroll too fast. So again, I don't know what was communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in our private conversations with Mr. Long, as I'm saying in front of Miss Bumpus, as I told you, that is what the order says. Glanville, and that is on direct or cross-examination. Miss Hilton, and that is on direct or cross-examination. Glanville. So if you're worried about what the defendants may ask you because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those things. Little Woody, I got family members watching this trial, and I don't want my nephew and them to hear the things that I may be involved in and think it's okay. Miss Hilton, but I think that's a separate conversation you can have with them as an honest individual. Like, look, nephews, I done lived the life that I don't want you to live. Don't go through what I've been through. But that's something you can have outside of being in jail, because that's a better conversation you can have with your nephews in person. But they shouldn't have to come to the DeKalb County Jail because you're being held in contempt. You can have that conversation with your nephews tomorrow in person. You can have that conversation with them. You can have that conversation with anybody. You know what's coming up this weekend. Why are we in jail? What are we doing? Little Woody. But y'all did this intentionally. Miss Hilton. No, we did not. You and I had this conversation, Mr. Copeland, on Friday morning. Little Woody. You knew my child's birthday was next week. Miss Hilton. But what did I tell you? When we met with each other, I said to you, you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And what was my response? If you plead the fifth. And that is exactly what you did on the stand. Little Woody. But what did I tell you before I got to that point? I told you the whole time, Tuesday, Wednesday, Thursday, Miss Hilton. But I told you we were giving you immunity. Little Woody, that I was pleading the fifth. Miss Hilton, no, you did not. Little Woody, I told you every day I was pleading the fifth. Miss Hilton, no, you did not. And we told you. Little Woody, I told you my concern. Miss Hilton, and we said we could give you immunity. You said your concern is what they know about you. And when you said that, I said, well, you know stuff about them. And then I said, whatever your concerns are, we can give you immunity. Little Woody, so I didn't tell you I lied on them to get myself out of the situation? Miss Hilton, you said you were a liar. That's what you said. You said you were a liar. They knew little Woody was going to go rogue. Page 28 out of 56. And it's just starting. Miss Bumpus, was this recorded? Miss Hilton, no. Miss Bumpus, and did he ever say that Melnick was his attorney? Miss Hilton, no. This week, when we first met you in the car on Friday, we asked you, is Mr. Melnick your attorney? You said he's not my attorney. I haven't talked with him. Little Woody, no, I never said he's not my attorney. I said I haven't talked to him. Miss Hilton, you said he's not your attorney. You haven't talked to him. Then we continued to have a conversation. At no point did you ever say to us, hey, I want Mr. Melnick here. Hey, put Mr. Melnick on the phone. Little Woody, you didn't make me feel like I needed him. Miss Hilton, but if you needed him, we would have said, if you would have needed Mr. Melnick, we would have said to you, okay, just call him. So, I mean, that is our position. We don't want you in jail. We just want you to be able to purge yourself by testifying. Whatever your truth is what your truth is. But you have to just get an answer to the questions. We believe that whatever your truth is what your truth is. We know what you said before. I don't know what you're going to say on the stand. But what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions is how you answer your questions. I know what you said before, and I know what you said later. I mean, I know what you said before, and I don't know what you're going to say on the stand because you and I never went into full details about any of it. Simone is repeating herself here, guys. But what I don't want is you to be sitting here in custody. Little Woody, you did it. Miss Hilton, I did not do it. You did it by pleading the fifth. Little Woody, you told me before you went to the judge with whatever the thing called you went to him with, you told me that I can't, when I'm asked the question, I can say I don't recall or I don't know. You told me that if I plead the fifth, I mean something. Why would I plead the fifth to something I ain't do? And I said, you don't know what I did and what I ain't do. And then you was like something. And then y'all asked for this immunity. And I was like, it was something. And then Friday came, and then y'all go and tell me, oh, we went to the judge with this, so you got to testify. If you don't testify, the judge gonna lock you up. Miss Hilton, right. But that was based upon you, Little Woody. But I told y'all that. Miss Hilton, no, you didn't. Little Woody, you said, why would I plead the fifth to something I ain't do? And I said, you don't know what happened. Miss Hilton, and I said, I don't know what happened. Only you know and them know, I said. But you never said I'm pleading the fifth. You said, what if I do this? What if I do this? What if I do this? Little Woody, I told you, I said, I'm going to plead you said, why would you plead the fifth to something that you know you ain't do? Miss Bumpus, so if you didn't have immunity prior to, is that what you're saying? That you feel like he didn't have immunity prior to? Little Woody, immunity came Friday right when I went to jail. Miss Hilton, the immunity only came after Mr. Melnick. Miss Bumpus, hold on. Miss Hilton, the immunity came after Mr. Melnick sent us an email saying my client is pleading the fifth. That was on Thursday evening at 6 p.m. Miss Bumpus, okay. Miss Hilton, so after that was an empathic? He was pleading the fifth. Miss Bumpus says, Miss Hilton says, we came and we got this signed. Miss Bumpus, Miss Hilton says, and then Friday morning came, and then Kayla says, okay. Miss Hilton says, so between Friday evening, Mr. Melnick reached out to us and he represents him. He's pleading the fifth. Okay, I'm going to stop for a minute, guys, because I already spot something. We were talking to Kayla, and Judge Glanville went through a timeline, and he said Kayla and Little Woody had an hour conversation out of the chambers. I've been reading this for like, I don't know, almost an hour now, and we're on page 32. We're halfway through the transcript. Glanville didn't give us a correct timeline. Let's go back in. Miss Hilton, so between Friday evening, Mr. Melnick reached out to us, said he represents him. He's pleading the fifth. Miss Bumpus, Okay. And when was the last time you talked to him before Mr. Melnick got involved? Miss Hilton, we talked to him early that day on Thursday. Miss Bumpus, okay. Then how did speaks to, the court reporter couldn't hear it. She was talking to Little Woody. Little Woody says, he called me. Miss Bumpus says, okay, I was just trying to get a timeline. Miss Hilton, sure, right. So we have been talking since last Friday. So I met with Mr. Copeland last Friday, I think out in the neighborhood. Then he came on Tuesday for court. We talked briefly on Tuesday, and then on Wednesday he came. Little Woody said Thursday. Miss Hilton, no, I think he only came 2 days, so it had to be Wednesday and Thursday he came. It wasn't Tuesday. It was Wednesday and Thursday he came. And then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point is when we went to the next morning and got the immunity motion. And then we spoke on Friday morning. I handed Mr. Copeland this agreement and let him know that he has immunity and that anything he says we cannot use. Then Mr. Melnick came, and then we had court. Miss Bumpus, so you're pretty much saying you didn't ask for this. Little Woody, I didn't. Miss Hilton, but we gave it. He doesn't have to ask for it. Miss Bumpus, I know. I'm just saying. Miss Hilton, right. He doesn't have to ask for it, but to alleviate whatever his concerns were, we gave him immunity. He didn't have to ask for it. Miss Bumpus, so if we wouldn't have had this, I'm just saying this is so he can understand it. I'm walking him through. Miss Hilton, Miss Bumpus, would he still have to testify, or would he have been able to plead the fifth? That's what he's saying. Miss Hilton, if he did not have immunity? Miss Bumpus, yes. Miss Hilton, yes, he could plead the fifth. Little Woody said, that's what I'm... Miss Bumpus, that's what he's trying to say. He's trying to say he didn't have to ask for this. Miss Hilton, but he doesn't have to ask for it now that we've given it to him, because that's on us. So now that we've given it to him, it's in order. He can still choose if this is the road he wants to take. Then he'll just stay in custody until the trial is over. Oh my God. And then we say the trial is over. Every last defendant has been tried. Not just these 6, the other ones too. Little Woody says, I done did longer time. Miss Hilton, all right, Mr. Copeland, I'm telling you that you are literally immune from prosecution from anything else you may say. That's that. So the choice is always up to you. But we wanted to put on the record, the state does not want you in custody. What the state would like you to do is purge yourself from Little Woody. What purge yourself mean? Miss Hilton, meaning that you are no longer in custody, and the way that you purge yourself is to testify. That is kind of how it happens, and that is what the state wants you to do. We want you in custody. We don't want you in custody. We can't say that we can't say that any other different way, but we don't want you in custody. The only thing that's holding you is you refusing to testify. Glanville. So do you have any questions, any other questions? Basically, if you invoke the fifth, Little Woody, I don't know what's going on. I don't trust nobody. I don't trust her word, but I don't know what's going on, Your Honor. Miss Hilton, this is your insurance. I don't know if you want to break that down to him. Miss Bumpus, well, he doesn't want that. Glanville, but he's been given it. See, that's the challenge, Mr. Copeland, is that if they didn't give you the immunity, you could invoke your Fifth Amendment privilege. But what the state decided is that they said your testimony is worth more to them at this point in time, and they really want to know what you have to say. So they have made from the state's perspective, they have made a decision to give you immunity so you no longer can invoke your Fifth Amendment privilege. You have to testify. So that's the difference in this particular scenario, is that they have taken away, well, you can still invoke your Fifth Amendment privilege. You still can do that. But the consequence of invoking it is that you will just remain in custody. So if you testify, you get out of custody, and you can stay out of custody until you are done. Little Woody. And then if I don't testify, I have to stay until when? Judge Glanville, until the trial is over, until all of the defendants have been. I've got these 6 that we have right now. And then there's another 6. Miss Hilton, no, there's another 12. Witness coercion, just saying. The court, meaning Glanville, there's another 12 or there's about that are still outstanding in various forms or another. Little Woody, can I speak with her for a second? Glanville, yeah, sure. So this is the point, 36 pages in. This is the point where Little Woody leaves the chambers, and Little Woody goes and speaks to Kayla for a little bit. Judge Glanville, ADA Simone, court reporter, investigators Long and Rashid left the chambers at 10:17, and they came back at 10:33. So look at that, right? That's already a misconception. Little Woody and Kayla only talked for 16 minutes. That is not the timeline that was recorded in court today. Oh my God. Little Woody, my question is, I can ask you a question? Glanville, yes. Little Woody. So my question is, so what I was just asking her was, if you ask me a question and you feel and I was lying about it, will you lock me back up? Miss Hilton, no. If you are saying, you say, I didn't talk to Demikion, well, no, I can't talk about that because the judge is in here. You are asking, for example, if you said before that the sky was blue, and I asked you on the stand what color the sky is, and you said, I said the sky was red, I'm going to say no back before you ask me it was blue. Is that what you're trying to ask me? Simone said that to Woody in these chambers. Little Woody said that shit on the stand 4 days later on Thursday. Remember the week he was being difficult? Remember the shoes? Remember when he looked at the court reporter and he repeated that exact same thing? He was a lot smarter than we thought he was. Shout out to Little Woody. What you mean? Oh my God. Miss Bumpus. So explain the independent evidence. If he says he did something and you know he's not telling the truth, what happens? Miss Hilton, if he said he did something and he did not do that thing, Miss Bumpus, if you believe he did not, so if you believe that he's lying about that, Miss Hilton, then no. If he admits to doing something on the stand, and he did not do that thing, I'm going to say, if this is the first time you are saying that, Bumpus, if you have independent evidence to prove it wasn't him, then what? Hilton, then nothing. What do you mean? Like, Bumpus, so then he will be fine? Miss Hilton, yes, but Bumpus, so you're okay with him if he got on the stand and said things that weren't true? Oh, shout out to Kayla. That was good. That was good, Kayla. That was really good. Miss Hilton, no, I want him to tell the truth. What, let me go back. What have I always said to you? I want you to tell the truth. I don't know what's going to come out of your mouth. I expect you to tell the truth. If you say something that is inconsistent with what you said before, then I'm going to ask about the inconsistencies, but I expect you to tell the truth. What you go on the stand and do, I don't know. I don't know what you are going to do. I want you to tell the truth, but I will deal with you, not you saying something different in the matter of that I normally do. Little Woody, if I'm saying something different, right? So when the police question me, they don't question me every time they lock me up. I don't know how many times that was. I done told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I done told them. Miss Hilton, okay, you can say I don't recall. That is how that works. I don't recall. Miss Bumpus, and he can say that to every single question? Miss Hilton, I would hope that that is not the truth, because I think there are some things that you do recall and some things you don't. But the things you don't recall, you don't recall. And then I will go through my process of what I do. You can talk to him about what impeachment is. That won't get you locked up. Impeachment will not get you locked up. You can talk to him about what impeachment is. If he says, I don't recall, Little Woody, what will get me locked up? Miss Hilton, what did I tell you? Little Woody, I don't know. Miss Hilton, what you did on Friday. I pled the fifth. If the court instructs you, Little Woody. So the only thing that gets me locked up is pleading the fifth. Miss Bumpus, yes. Miss Hilton, the court instructs you, you need to answer the question. You say again, I plead the fifth. Again, that's what's going to get you locked up. But if you answer the question, that will not get you locked up. Little Woody. So if you don't want me in jail, why just don't you let me go after the trial over with? Miss Hilton, you are in jail because you are not answering the questions. Glanville, because you have been given immunity. Miss Hilton, because you have been given immunity. You are only in jail because you got up to here. Little Woody, well, what about this? I answer the questions. You take away the immunity. I answer the questions and I plead the fifth. Miss Hilton, no. Miss Little Woody, to questions I feel incriminate me. Miss Hilton, but then that's Little Woody. I won't plead the fifth to things that don't incriminate me. Glanville, the state will still give you immunity. They can give you immunity to whoever they want, or they can give immunity to whoever they want. Okay. And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure it's that the jury needs to hear what you have to say, good, bad, or indifferent. And that's what Miss Hilton is telling you, is just tell me the truth as you know it and let her worry about, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. What will get you in trouble is just invoking your Fifth Amendment privilege because you have been given immunity. Or as Miss Love said this morning, remember Miss Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they're going to indict you on that particular charge. That particular false statement. Little Woody. That's what they're going to do. Miss Bumpus, that is what I was saying. You will be right back here. Miss Hilton, but if you say something that you know you did not do, like you admit to something you know you did not do, whether you, Little Woody, like murder don't have like no statute of limitations, right? Oh, God. Miss Hilton, but if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it. Little Woody, but y'all don't like Miss Bumpus. You can charge him with false statements and he will be back in jail. That is what I'm trying to say. Miss Hilton, but if I know that you're lying about that, I don't intend to do that. But if I know right now he's lying, I know he's lying. I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you were trying to say you did now. And that can be a part of this. I know you didn't do it. Little Woody, but it's up to the judge to do that, Miss Hilton. No, it's up to the state to bring charges. Glanville, I don't have anything to do with that. Miss Hilton, he has nothing to do with bringing charges. That's up to the state of Georgia. Little Woody, can I talk to my family and I will make my decision right after I hang up the phone. Miss Bumpus, he's saying he hasn't been able to speak to anybody. Miss Hilton, his sister just called us. Little Woody, y'all done me wrong. Y'all just hold me in jail. Don't let me get no PIN number, no nothing. Miss Hilton, we have no knowledge. We did not know that you, Miss Bumpus, he hasn't been able to do anything, speak to anyone. Little Woody, the jail system down, but y'all still putting people in it. Miss Hilton, that part I don't know. I don't know. We have been in communication with your sister. Your sister actually texted Miss Lenskoy to make sure you were okay. We told her we physically have laid eyes on you. I'll leave that up to the sheriffs. I don't know. Little Woody. So what you think she's saying? Miss Hilton, I can't tell you right now. Little Woody, I'm talking about that locking me back up. Miss Hilton, we would have to bring charges. There would be no incentive. Little Woody, y'all will. Miss Hilton, we've already had this discussion. Little Woody, look at what you did to me. You waited until Friday and did this. I done told you every day before Friday came that I was pleading the fifth. Miss Hilton, no, you did not. As a matter of fact, our last Glanville. Mr. Copeland, let's see if we can get beyond this, okay? Beyond what your concern is. You could have invoked the Fifth Amendment privilege. The state could have turned over around and said, stop, had me go ahead and file that motion and given you immunity. It was going to, they can make that decision. They decided to make it on Friday. So even if you would have been more comfortable testifying or invoking your Fifth Amendment privilege, they could decide you as a witness, they want your testimony more than they do you invoking our Fifth Amendment privilege. So they give you immunity. They gave you immunity. So you've got to testify truthfully as to what your knowledge of the particular incident is. I mean, so they could have done that anyway. Even if they put you on the stand, they could have said stop and gone ahead and given you immunity. They could have done that. Little Woody. So can I get it in some type of writing that if I was to testify, that if she feels as if I lied about anything, they won't lock me back up? Glanville. Let me have that, Miss Bumpus. Miss Bumpus hands a document to Glanville. Glanville says, Mr. Copeland, on page 2 of the order, according to OCGA 245507, however, no testimony given by Kenneth Copeland as required under this order or any information directly or indirectly derived from testimony of Kenneth Copeland is required under this order shall be used against said Kenneth Copeland in any proceeding or prosecution for a crime or offense concerning which he testifies under this order. Okay? So you testify about some aggravated assault or murder, they can't prosecute you on it because that is what it says in the order. Okay? The only thing that will get you in trouble is this next little paragraph. Kenneth Copeland shall be subject to prosecution or the penalty or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court in this state, the United States, or any state. So basically, if you commit perjury, false swearing, or contempt committed in testifying, that means if you just invoke your Fifth Amendment privilege or failing to testify, you say, I'm not going to testify. All right. So the only two real things you can kind of get in trouble for are perjury and false swearing, as long as you tell the truth. Now, as Ms. Hilton and Ms. Bumpus said earlier, you may have been told or have been asked about situations over and over again. They may have changed. When the state is asking you to do, what the state is asking you to do is tell the version that really is the truth. If they want to impeach you, they can do that. Or if the other side wants to impeach you, they can do that. You won't get in trouble for that. Little Woody. You said I will. Glanville. You will not. You will not. Impeachment is not perjury or false swearing. Okay? Little Woody. But she said I can purge myself, though. Miss Hilton. No. We're saying two different things. Sorry. Perjury is if you get on the stand and you just say a bold-faced lie. Just something that is just wrong. Say you say, I did something, and all the other times you said, I have not done it. And really, while it's perjury, it's really just an inconsistent statement. Oh my God. Like if you get on the stand and say, I did X, but in 2015, you said, I never did X, then that is what I'm going to impeach. I'm going to impeach you on everything you said in 2015, meaning I'm going to say, okay, today you said I did X, but in 2015, Lieutenant Dean enters the chambers. Lieutenant Dean, we have a security issue. We need to stop for a minute. If we can stop for a second, please. Judge Glanville and Lieutenant Dean exited the chambers at 10:45. Glanville returned 2 minutes later at 10:47. Miss Hilton, I don't know what was told to you on Friday. I have no reason to want you in prison. You have spent enough time in prison for YSL, period. So why would I want that for you? It doesn't make no sense. I said it to you before, and I will say it to you again in front of all these people. It makes no sense. Little Woody, you just said I'm going to have to stay in jail until the last. Miss Hilton, if you don't testify. Get this part through your head. If you don't testify, that is the only thing that is holding you. That is literally the only thing holding you right now is the fact that you keep saying, I'm not going to testify. Well, you haven't said it today. I'm not testifying. I plead the fifth. If you get up there and I want you to tell the truth, like I said before, if you don't recall certain things, you can say you don't recall. That's fine. I want you to tell the truth. I don't expect you to remember every single detail from 2015. I just don't. No one here does. But what I do expect for you is to answer questions so we can get through this. So you can go home, be with your baby for her birthday, see those dogs deliver their babies, go talk to your nephews, and do all these other things. Little Woody, how you know about my dogs? Miss Hilton, because you told me. Little Woody, okay. Miss Bumpus, what's wrong? Little Woody, I'm stressing at another level like Miss Bumpus. I mean, I'm just saying. Little Woody, I'm weak. Man, I'm not playing. I'm dead serious, man. Like, Miss Hilton, this is what our position is. We do not want him in custody. We want him to tell the truth. We want him to testify. That's what will get him out of jail. And you you have to make Miss Bumpus. If he decides in 2 weeks he wants to testify, then what? Miss Hilton, if he wants to stay in jail for 2 weeks, then I don't know why you would want to stay in jail for 2 weeks. I have no idea. Miss Bumpus, he just feels like he's under a lot of pressure right now. Mr. Copeland or Little Woody, even at the jail, they are just, you can't give me a house arrest. Miss Hilton, no, you can go home by taking the stand and testifying. That's what you, and again, sorry guys, let me shut this window. It's really distracting. 1 second. 1 second. Like I'm like thinking of the sound over here. Sorry, inner city sounds. Okay, Miss Hilton, no, you can go home by taking the stand and testifying. That's what you, Glanville, and come back tomorrow. Miss Hilton, we keep on saying yet, but there's no crime. We keep on saying yet, I don't know who's really telling you about a crime. There is no crime. You have done nothing wrong except for Little Woody. So why am I in jail then? Miss Hilton, because you aren't testifying. Little Woody, but that ain't nothing wrong. It's not a crime. Miss Hilton, it's not a crime that you're in civil contempt. The court, Glanville, 2 things. Because you invoked your privilege after you've been given immunity, that is why you're in custody, because you get out by testifying. So you testify, you get out. That's why I was going to bring you why I brought you here early today, just to inquire about that. You can remain and hold your position of invoking the fifth or not testifying, but you go back to prison. You go back to jail because that's Little Woody. You can't sentence me? Miss Bumpus, there's no sentence. Glanville, there's no sentence. The contempt is compliance. We want your testimony. That's all they want, whatever that may be. Little Woody, I don't know what it is, Your Honor. Miss Hilton, so listen. You're in jail for failing to testify. Glanville, failing to testify. Miss Hilton, not for nothing else. There is no crime. You ain't done nothing wrong. I don't know if people are telling you what we are going to charge you with. Nothing. We are not charging you. The state charges you. There is nothing we are charging you with. You're only in custody because you have decided not to testify. That's it. Once you decide to testify, Glanville, remember that word you were talking about, purge? Little Woody, The court, okay, you can purge right now. Purge, get yourself out of jail just by testifying. Little Woody, I can purge and get out of jail? Glanville, yes, just by testifying. Miss Hilton, not perjury. Glanville, purge, meaning you can get out of jail. You can get out of jail, out of custody just by testifying. Little Woody, and what about the other one, the other word, perjury? Glanville, that's different. Miss Hilton, that's different. Glanville, that's a different word. Okay? Little Woody, that can get me back in jail? Miss Hilton, yes. Glanville, perjury is, Miss Hilton, it's not what you are saying it's not what you were saying is not perjury. What you are saying is what we call a prior inconsistent statement. Your example that you gave me, what if I said I did something and I know you didn't do it and you said before you didn't do it? That's not perjury. That's a prior inconsistent statement. Miss Bumpus, you've got to make a decision. So if he starts testifying today, he's going to go home today? Miss Hilton, he should, so long as he remains. But if you get up there and be like, if you get up there testifying and then we get into it and you start saying, I plead the fifth, we're going to be back here again. Miss Bumpus, but if he says he don't recall to everything, he'll be okay? Miss Hilton, I'm not advising that. But so long as he answers the questions, that's fine. So long as he, Little Woody, I did these crimes. I'm telling you that. Miss Hilton, okay. I don't know what you're talking about, but Miss Bumpus, I think you are saying you want to get up there on the stand and say something. Little Woody, he stayed quiet. No response. Miss Bumpus, did we find out if he could talk to his family? No? Miss Hilton, I mean, if it's okay, we got the sister's phone number. Lil Woody, as my attorney, you gotta, Miss Hilton, if y'all want to talk, let me go somewhere. I can't hear you. The judge is over there, so just speak low so he doesn't hear you. Glanville, hold on. Judge Glanville handed a document to attorney Caleb Bumpus and exited chambers with Assistant District Attorney Simone Hilton, Investigator Long, Investigator Hamilton, and Court Reporter Christina Weaver from 10:53 to 11:28. Okay, so it does look like Little Woody got at least 35 minutes with Kayla, with Miss Bumpus. Moving on, Glanville. Okay, all right, Mr. Copeland, have you had an opportunity to talk with Miss Bumpus, your lawyer, and Miss Hilton and the state's counsel? Have you got any other questions? Lil Woody, no, Your Honor. Glanville, is it your desire to give testimony today? Lil Woody, yes, sir. Glanville, okay, all right then. Do you all have some clothes for him? Miss Hilton, I don't know. Let me go take a look. What size are you? Lil Woody, I can't hear you. Miss Hilton, what size are you? Little Woody, little. Investigator Hamilton, we've had a large jacket for him on Friday. Large. Miss Hilton, you had a jacket for him? Investigator Hamilton, yes. Miss Hilton, oh, but he can't wear a large? Glanville, what is your waist size? 34? Little Woody, 32. Glanville, chest, what are you? 34? 34, 6 chest? Hilton, probably 36. Woody, not in my chest. What you mean? Guys, we have our first what you mean citing in this document. It's wonderful. I really enjoyed that. Glanville, what are they going to try to get you some clothes? They are going to try to get you some clothes so you don't have to testify wearing that jail uniform, okay? Little Woody, y'all don't want to show the people how y'all did me? Glanville, look, Miss Hilton, if we can't find clothes, then you may have until tomorrow. Little Woody, I prefer to go in like this. Miss Hilton, I understand what your preference is. Little Woody, nah, don't hide it. Miss Bumpus, can you make him put on clothes? Miss Hilton, no. Little Woody, I want to go in there like this. Miss Hilton, fine with me. Glanville, all right? Okay. Mr. Little Woody, y'all ain't going to try and lock me back up for this? Miss Hilton, so long as you testify, we will get an order to get you released. Miss Bumpus, today. Glanville, whose copy is this? Miss Hilton, you've got to make sure you come back now. I want to be real clear. Little Woody, when have I ever ran? Miss Hilton, you have not. That's the only thing. You have not. Glanville, whose copy is this? Miss Hilton, that was ours. Do you want a copy? You can take it though. Miss Bumpus, okay. Miss Hilton, do you still have yours or you threw it away? Miss Bumpus, I'm going to give him both of these things so he can have some information. Miss Hilton, okay. The court reporter, are we off the record now? Glanville, are we done? Miss Bumpus, yes, I believe so. Glanville, okay, we're good. See everybody downstairs in about 10 minutes. The proceedings concluded at 11:31 a.m. This is a certificate. This is signed by Christina Weaver, the court reporter, certifying that everything on here is true and the way that it was transcribed. And ladies and gentlemen, I apologize for the background noise. That is the transcript from the secret meeting. We did it. Shout out to me. Lots of hours of streaming, many super chats and cash apps that were not read. I was not able to read and watch you guys in the chat. Yes, Lonnie, phew, I'm sweating. Babe is next door, all types of shenanigans. Let's come to, I love you guys. I would not do that for a lot of people. I even did the Woody voice, buy some merch, like help a sister out. Oh my God. Okay. All right. Let's come to some supers. Let me close out the night with you guys. I didn't hear back from Lead and we got through it anyway. So that's all good. All right. I think I left off over here. Shout out to Devin who says, how do I become a member? We talked about that. Shout out to Shampoos, $20 says donating because you are so gorgeous. Thank you so much. I'm not so much right now. I'm probably sweating profusely. The life of a streamer. Shout out to Candy Yates, one of my faves. Thank you so much, Candy, for the $19.99. She says, great job keeping us informed, especially with all you have going on. You're amazing, sis. Listen, I do it for you guys. And for all those people that were like, you're wrong. I bought Doug Weinstein on. Can I get a like? Can I get a comment? Can I get some love, some amens? That would be fantastic. The Mushroom Podcast, your main man Mush, has become a new member. Welcome to the community. Shout out to M. Ray, the boss, for the $5 super. Thank you. He says, AV, you're doing an excellent job. Thank you so much. I needed to hear that. Thank you. Ray the boss. You have no idea what that means. Shout out to Mike in 10 with the $50 super. One of my favorite people. He says, got here late. Now I have to dip. Great shows today. No one appreciates your content more than me. Now, hashtag, it's to say 100% hashtag shareholder. I like to call like my biggest, folks that take the time. I know you guys don't have to do it. Every single dollar matters to me. But when people step out the frame, like Mike, like he's always supporting me. And I always like to tell him that. And I use terms like those that really support your girl are shareholders. You all are. You guys are all shareholders in my YouTube experience. You really are. You're spending your time here. You could go to any other channel that you want. I got that thing hot off the press and made sure that we sat through 56 pages and read it. But that should bring you all up to speed. Thank you so much again, Mike. You're one of my faves, and I can't thank you enough for all the support when you're modding and monitoring the chat and doing all that you do for the community. So thank you so much. If y'all could type Mike in 10 in the chat, that would mean so much to me. Thank you so much, Mike. Shout out to D, who says, hey, AV7 with the $2. Thank you so much, D. Shout out to Fletcher Boy with $9.99. Thank you, Fletcher Boy. He says, this trial highlights serious problems in the Fulton County's DA's office. I'm going to take tonight to think about that and digest it into a smaller video because there's a lot of problems. And I'm sure you guys have seen them. I'm sure you've seen what those problems were. It was very clear that little Woody didn't understand a lot of things that were happening. And to a point, he did understand some stuff because he's like, you don't want to show the world what y'all did to me. I want to go out in the courtroom like this. His behavior now makes so much more sense. And I hope you guys see that, So thank you so much, Fletcher, for that one. Shout out to Michelle, one of my faves. She drops $5. She says, AV7, what does it mean for the defense? Why do they not want his arrest shown? What you mean? I think the defense, I think I remember what you're talking about. They didn't want little Woody's arrest shown. And this might have been around the time I was reading Brian Steele's motion. I'll be honest. I'm like your main man mush. My mind is like mush right now. So I can't give you a precise answer on that, but I'll make sure to put it in the video when we recap Brian Steele's contentions, because that was so long ago. I completely forgot what those contentions are. So I'll come back to that one, Michelle, but thank you so much. And bear with me. I'm just getting sleepy over here. Shout out to Sammy with $4.99. Sammy says, has someone ever told you look like Yesha Curry, Steph Curry's wife? No. However, people have said that I look like Steph Curry, which is a little mean. Isn't that crazy, Sammy? Thank you so much for that. Shout out to Tavisha. I hope I said your name right, sis. She says the transcript is out. I just read it. We just read it, guys. Shout out to Audrey. Okay, this must have been when it came out. Audrey says, let's go. Neek says, AV is that go. Like, y'all are ready to get into this transcript. I'm so happy. Oh my God, you're all here. Shout out to Lady Di. She dropped 10 AV to the 7th Power memberships. If you have a membership, please tell Di thank you. In fact, to reward the new members, I think I'm going to make one of these videos exclusive just for you, so the public won't get it. All right. So I want to reward you guys for all the hard work. And Lady Di, super nice. I haven't seen you in a minute. She's one of my favorite mods, and she's out here gifting membership. So if you got one, say thank you. And for all those that received it, welcome to the community. Shout out to the one Lo-Fi Terica. She says, Bumpus, not my money, not my circus. I'm out. Exactly. Shout out to Kayla. And if you guys haven't checked out the one Lo-Fi Great Beats, check out her channel. If any of the mods are hanging around, drop a link to her channel. But she's right. We had a great chat with Kayla earlier today. It was fantastic getting her point of view. Terica's back. It says Little Woody fired Miss Bumpus to protect her. I think he did, because seemed like they were getting along rather well after reading this transcript. So thank you so much, Terica, for that one. Shout out to CP3 with $4.99. No comment, no question, pure love of the game. Thank you so much. Shout out to Chill Panda with $1.99. Says Woody off nut, plain and simple. You know what, Chill? And is it just me? We went through all 56 pages, guys. I don't see him saying that in here at all. So maybe there was an issue with the telephone game. I know I'm not crazy. I did not see any references. I'm going to do find on the document just to verify it. Find and document any references to. I just typed in Nuts government name. It's not in here. So it's not in here. So Chill Panda, I know you're saying definitively Woody did it, but it's not in this document. At least that conversation didn't come up. So thank you, Chill Panda. Shout out to Mahadi. I hope I'm saying your name right. You're the Massachusetts person? I think you are. Thank you so much, Mahadi. That's super, super generous of you. He says, AV, loving the murder mystery character voice readings. Y'all see me get into character. I'm like, this is what this person says. This is what this person says. I was in it. Yeah, especially when I got into character for Little Woody. Man, I should be doing this like for movies or something, right? Shout out to Buddha Bell, who sends a $5 super sticker. Thank you so much, Buddha. Super, super nice of you. I appreciate that. Shout out to Chris Gloss with $19.99. Chris says, great job, baby. Thank you so much, Chris. I really try to make this entertaining for you guys. And I'll be honest, I was kind of dying a little bit in the middle with Brian Steele's thing. But when this came out, I was like, we're going to do it. We're going to power through it. So thank you so much. Shout out to Neek Neek with $1.99. Says AV's little Woody voice got me in tears. How about the what you mean? It was good. It was good. I'm glad you got some entertainment from that. I think I do a pretty good Woody impression. Hopefully he doesn't get mad at me. Shout out to Tough Woman with the $1.99 super sticker. I like your name, Tough Woman. Thank you so much. Shout out to IG $4.99. Says AV, this is a good thing for Thug. I didn't hear little Woody confess murder. Me neither, IG. I was just talking about that. I did not hear him confess to the murder at all. I know I'm not crazy. Shout out to Dub Right Side, just becoming a member. Welcome to the community, brother. So happy to have you over here. Oh, look who it is. One of my faves. Boston Mass with the $20 says, hi, good job. Listen, kid. I know you're from Boston. Like, he brings out the Boston accent in me from time to time. We park the car in Harvard Yard all the time. You know, I'll meet you at Dunkies in the morning if you want, kid. So good to see you, Boston, Mass. You remind me to bring out my Boston accent from time to time. Good to see you in here tonight. Thank you so much for the super. Shout out to Anything But the Norm with the $9.99. She says, I think it's a she. She says, I'm new here. I came over here from seeing you on The Lead Attorney. You do a good job. What brand is your glasses? So I usually put this in my description box. These are Jack Marie Maj. 24 karat gold on the side, and literally they only make 500 of these at a time. I put my shape in there, so but they have really good stuff. They have great sunglasses too. They're super durable. I've had these for about 2 years, so please check them out if you are interested. Shout out to R Live TV $4.99. Thank you. He says, I love your work. You and TLA rock. We're a great team. Shout out to Trina. Thank you so much, Trina. Says, thank you for your videos. You're welcome. We work hard. I just hired somebody else to help me on Friday. So Team AV7 is growing. We are growing, and it's really powered by you guys. So thank you for all your support here. We're going to get you as much content as we can. Shout out to Buddha Bell, who became a new member. Thank you, Buddha. Welcome. Shout out to Heart of Inspiration with $10. She says Woody wasn't scared of street justice, but he specifically asked about unaliving someone. And then he said he did these crimes. That's the thing. Brian's document that we read before this, and I'll timestamp this out when I'm done, guys. Like, I'm going to grab something to eat and like timestamp this out if you're watching it on replay. But Brian Steele said that the state knew, and this is proof in these transcripts, they knew that little Woody was going to plead the fifth, and that they knew that he was going to do that. They knew that he was lying about things. There was so much about little Woody that is being unraveled in this document that the state knew about, and we all sat through and watched that could have been prevented, right? So, girl, yes, he said he did these crimes. He sat on the stand and told us that he was busting guns and shooting at people, you know, and you could see it here. He was afraid to tell some of those things because he didn't want to be tried for those crimes. So, too funny. Shout out to the One Lo-Fi again with the $10. Says AV. Also, go back and listen to what Bumpus said this morning. That Woody didn't say anything about nut at all, but someone took it and ran with it. Exactly. I just read it. I didn't see it in there. Oh my God. Thank you, Terica. Shout out to Judge Glanville's complaint. Thank you. I needed this laugh. Judge Glanville's complaint, $4.99. This is actually a photo of Lead ripping up a complaint. And some of y'all are so good with trolls that somebody clipped that up and turned it into a troll, and it is amazing. It says, your name on the next complaint, Sam Cassell's sister. If you were in the stream earlier, then you know, oh my God, y'all are crazy. Shout out to Ivy Young with the $4.99. Ivy says, he said, I did these crimes, but they acted like they didn't hear it. Exactly, Ivy. Ivy. He said it like, how many times did he say that? And it just glossed over. It's so nuts. Shout out to the one lo-fi again. Tara, you blessing me tonight. Thank you. Thank you. With the $5 super sticker. And look at who we have. We have another troll. We have Jack Glanville, the service dog, with $9.99. He says, you the real MVP. Thank you so much. All right, guys. I think I've finally caught up on Super Chats. There's Cash Apps, though. So let me make sure I read all of these off. You guys have been such a huge support going through this today. And this is one of my favorite streams on my channel. It was super, super eventful. After I left Leeds, a few of you guys sent me some things. So I just want to make sure I get all of them. I'm going to start with Jackie. Shout out to Jackie, who sent me $10. This is over on Leeds side. She says, joined as a new member a few days ago. Thank you, Jackie. Welcome to the squad. Jackie sent that over. Shout out to Icapone, who says, obrigado, professor AV, estão aprendendo. And he's talking to me in Portuguese, so I apologize, guys. That's a thing me and Icapone have. So thank you so much, Icapone. Shout out to Denise with $10. No comment, no question, pure love of the game. Thank you, Denise. You're a sweetheart for that one. Shout out to Q Rich with $5. Says, I rely on you and Lead for the truth. Thank you so much, brother. Yeah, and then that's the thing. We're not gonna lie to you guys. We show you these documents for a reason. We show them to you. We're not hiding the ball. You see it and you get it here first. We try to do it with speed and precision. Denise is back with another two that says, forgot to say the last one. You rock, sister. Right back at you. Thank you so much, Denise. Shout out to Liz with $1. Says, why can't the defendants get bail now? Well, we're gonna see what happens tomorrow, Denise. I mean, I'm pretty sure, because this document just dropped at like 7:30, 2 hours ago. Doug was here with me, and I guess he was anticipating this. Maybe he had an opportunity to read it at this point in time, right? But we will see what happens. I mean, I think all the defendants want a not guilty verdict. I think all the defendants have wanted bail and have been denied. I don't know. Everybody's situation is different, so we'll see what happens. And then lastly, on the Cash App side, Beth, thank you so much for the $20 Cash App. No comment, no question, pure love of the game. Okay, I think I'm all caught up. I'm going to come back over here to make sure. All right, DJ Dunbar, Grapes, he pops in last minute, $2. Thank you so much. I saw your video that you tagged me in. Welcome to YouTube, brother. Going through a lot of health issues. I hope you feel better. I hope you start to heal and feel better. Prayers to you and your family. All right, y'all. I hope you had fun on my side tonight. We got a lot of things happening. We've done this for just about 3 hours. It's going to be great. An eventful week. More to come. Lead and I are probably going to be back tomorrow. I know we want to invite Kayla back to look at this document in detail. And now she's going to be able to recall the events, talk about some certain things that happened. But I can tell you guys one thing off the top of my head. In court, Judge Glanville said that she and Woody were in a room for an hour. And as you guys can see, that was not true. So hopefully that was just a mishap. But yeah, and I did see some corrections in his order. So maybe that's what that was. And there was a misspeaking. You guys know I do it all the time. Like I used the word mistake last week. Y'all roasted me alive. And then I love you so much. So I brought Doug here to clear it up. Right? Anywho, I hope you guys all have a wonderful night. Let me know what you think in the comment section. We have a great community here. Let us know what you think. I'll see you in the next one. Stay safe out there.